Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Be seated, please. All right, the first case we'll call this morning is United States versus Glover and Mr. DeSimone.
Thank you, Your Honor. May it please the court, I'm Andy DeSimone, and I represent Nathan Glover. I plan to focus on issue 1, the district court's error in applying the 4-level enhancement for burglary, but I'm here for the court to answer any of its questions as to any of the issues. Mr. Glover objected to the PSR's allegations that he lacked consent to enter the house from either occupant. That put the government on notice that it had to prove those facts. The probation officer even wrote in the PSR, quote, "The government should be prepared to present evidence at sentencing." And at sentencing, Mr. Glover renewed the objection and testified that Miranda Mullen gave him permission to be there. So in the words of this court's decision in United States versus Terry, Mr. Glover thereby articulated the reason why the facts in the PSR were untrue and inaccurate, and as a result, the government could no longer rely on those allegations. The government knew it had to prove those facts, and here it just did not. If the government had that evidence, this would not have been a hard thing to do. The government could have asked its witness, Mabry, whether Glover had consent to be in his house. The government could have called Mullen to testify as to whether she gave permission to Glover to be there. The government could have called a police officer to recount statements.
Question. I think I know the answer to this, but I wasn't able to find something as clearly on point as I would have liked. Do we know under North Carolina law whether consent or lack thereof is an element of the offense of burglary or an affirmative defense?
It's an element of the offense under.
What's the clearest expression you've been able to find that said? I don't know if the North Carolina Supreme Court has ever overtly said that, but what's the? I tend to think you're right, but what's the best evidence of that?
I think the clearest case is State versus Boone from the North Carolina Supreme Court, talking about when the statute was enacted, it imported as an element that the breaking or entering must be without consent, and that's then discussed in Mungro.
So you think one way to view the record in this case is before the sentencing court, does he have consent or not? I don't know. Based on the evidence before me, one possible interpretation is it's impossible to determine whether he has. That's why I asked about the burden of proof. Who does that hurt if the record just doesn't tell me whether he had consent or not? Right. Here it was the government's burden, and there just was no evidence because they could not rely on the PSR at that point. But a few factual points I also want to clarify.
Rely on the PSR because the probation officer wrote in there what Mabry told the police that she did not give consent. Why can't the court rely on that?
Well, Your Honor, first, the only testimony about what Mabry told police was that he reported the theft of his firearm, not that he reported a breaking or entering. That's actually Joint Appendix page 43. But more to the sort of legal underpinnings of your question, under Terry, once the defendant objects to a factual statement in the PSR and then goes further and demonstrates that those facts are inaccurate or untrue, the PSR is not evidence at that point. The government must independently prove those allegations. And we objected to paragraph 8, which contains what Your Honor just referenced. So we objected to all facts related to the consent on that day.
What's the basis of that decision in Terry? Is that due process? Sentencing courts are allowed to rely on hearsay, right? There's no constitutional problem with relying on hearsay at sentencing. So what is the basis of this notion that once the defendant objects, the government can't just rely on the PSR? Sorry, the defendant.
Right. Well, while hearsay may be admissible, it's not just automatically admissible. The evidence has to be reliable because there's a due process requirement to reliable introduction of evidence, and I think it derives from there. I mean, it's more clearly delineated in the Poor Bear and Martinez cases, and there are multiple cases from all over the circuits about this situation. I think they didn't get there in Terry because the defendant didn't go far enough. The defendant only merely objected to the PSR, didn't do anything to show that the facts in the PSR were untrue and inaccurate.
So that's weird. I mean, that's really weird, right? I mean, I could imagine a world in which you're not allowed to rely on the PSR at all. I can imagine a world where you're allowed to rely on the PSR in the absence of an objection. Again, as a matter of like due process or the rules of evidence, I don't, candidly, we're bound by Terry, so I guess I'm saying I'm not sure that makes a lot of sense.
I tend to agree with you, Your Honor. I think it's too much of a burden to put on the defendant, but I gladly accept it in this case because we clearly met it.
And so you say putting on evidence is your client taking the stand and saying, I had permission, right?
Yes.
Once he does that, the government has to introduce evidence that says that's not true.
Absolutely. I did want to make a few factual points. Mabry's testimony was largely consistent with Glover's testimony, but only Glover testified about the consent issue. You know, Glover said that he and his lady friend, Mullen, went out together to the sweepstakes the night before and then went back to the house together. Glover then took a shower at the house and spent the night with Mullen in a separate part of the house from Mabry. There was just no testimony they even saw Mabry that night. Then when Mr. Glover woke up, Mullen was still asleep and Mabry was gone, and that's when he made the bad decision he did. I also want to make sure the court is aware of the layout of the house as far as we know from the transcript. So Mabry is in a wheelchair and enters the house through a door from the garage into his bedroom. He testified there's also a door from his bedroom to the kitchen, which always stays open. And then after the kitchen, there's the den and the living room in a separate part of the house, he said, which is where Mullen and Glover were sleeping. I also want to just emphasize, you know, there was no sign of forced entry to Mabry's house. And we're not dealing with a long period of time where Glover had consent. Again, Glover and Mullen went out together in the evening, they spent the night together at the house, and then Glover left in the morning. During that limited period of time, he had consent to be there. It was never revoked. Now, the government has three arguments why they say there was sufficient evidence, but none hold water. Again, first, they rely upon the PSR, but again, we objected to the PSR and they could not rely on it. They argue, second, you can infer lack of consent from Mabry's testimony that Mullen did not know who took the gun. But she wouldn't know for sure. By all accounts, she was asleep. But that does not mean that she did not give Glover permission to be at the house. It just doesn't logically follow that because she didn't know who took the gun, she did not give Glover permission to enter. And if we think about it from Mullen's perspective, you know, she allowed Glover to stay over only to have him then steal Mabry's gun. That must have been mortifying for her. So, I mean, while not breaking or entering.
Ask you this about what evidence would be necessary. Say the evidence was just that the defendant was a stranger to the victim. I mean, it's hard to imagine a hypo because I think the answer to all these is the victim just should just take the stand and say I didn't give the defendant permission. But you know, part of the appeal of your case relies on the sort of interrelationship between these people and the sort of inherent plausibility that your client might have had permission to be in the house. But imagine a hypo where it's implausible, right? Where, as far as I can tell, the defendant and the victim are completely unrelated to each other. They have no connection. There's no evidence the defendant has ever been in the victim's house. Would you really need the victim's testimony then, or could you just say, based on, you know, common human experience, it's unlikely that a person who's never been in the house was given permission to go in the one time they happened to steal something?
I'll tell you this. I mean, in the thousands of transcripts that you've probably read and I've read in my career, regardless whether it's a stranger or somebody they know, the government always asks that question. The government.
Put the victim on the stand and say, did you give Mr. So-and-so permission to be in your house?
Yeah, it doesn't matter whether the person is related, you know, or a complete stranger. That is always there, and it's just not here.
Can we derive anything from the fact that he filed charges of breaking and entering?
So as to that, again, the government says he filed charges, right? But the testimony, if you look at Joint Appendix page 43, is that he reported the theft of his firearm, not that he reported a breaking or entering. And then the government asked, quote, and that's when officers took out charges of breaking and entering and larceny of a firearm? And Mabry answered, yes, sir. So the testimony is not that Mabry pursued that charge. The testimony is that the police charged Mr. Glover with breaking or entering, but regardless, it is just a charging decision and nothing more.
Well, I know, but my question really is circumstantial evidence. You would assume the government doesn't make up charges, that they derived it from Mabry and talking to him and came up with those charges. And it seems to me it points in that direction. There was also a question sustained where the question was whether the girl gave consent, and it was hearsay, so it was sustained, but he said she didn't because she was sleeping.
Yeah, well, I guess that...
it's not all perfect, I can see.
Yeah, yeah. But that then, I stand on my first answer then. This sort of goes back to the fundamental problem here is that paragraph 8 made those allegations. It said Mabry told police X, he said Mullen said Y. We objected to all of that because we are saying he entered with consent, and that's not true. And then we testified at the hearing, and the government didn't counter that. The government did not counter even on this point that Mabry pursued charges. There's just no testimony of that.
There's testimony that he lived next door. He didn't live in the house. There's testimony Mabry was not at the house, and there's testimony that the girl was asleep and didn't know he was there.
Right.
So from that, when he gets into the house, isn't it? Can't you infer he didn't have consent?
I'm not sure if I'm following, but Mabry's in a wheelchair, remember? And so he testified that when he left that morning, he wheeled himself down the ramp from his room to the garage. And then when he came back, he came in the same way. He never testified he looked in the rest of the part of the house. So he wouldn't know if Glover was there or not. Now, in terms of sleeping...
Mabry didn't give consent.
Pardon?
Mabry clearly didn't give consent. But the question is whether the girl could have consent, and the testimony was she was sleeping the whole time and didn't know that Glover was there at all.
Well, no, the testimony is that he was there already. He went out with, this was his lady friend. They went out together. They came back to the house together, and they slept together. And then, in the morning, she was still asleep and he left. And there's really nothing to counter that.
Okay, anything else?
No, thank you, Your Honor. I'll reserve the rest of my time for rebuttal.
Mr. Knoll.
Thank you, Your Honor, and may it please the court, Andrew Knoll on behalf of the United States. As explained in our brief, we agree that the district court erred at imposing the challenged financial conditions of supervision for lack of adequate explanation, and that those specific conditions should be vacated, but the balance of Mr. Glover's sentence should be affirmed. And I'm happy to start with the 4-point enhancement under section 2K2.1 for the commission of another felony.
Can I just really quickly on the Booker? I mean, I think on balance, this judge probably made clear that it understood the guidelines were advisory. Does this happen a lot? That judges after Booker say, I have to do things, the guidelines make me do things. I mean, like I said, I think I agree that taken as a whole, the colloquy makes clear the judge didn't think something that's contrary to Booker. But in your experience, does this happen a lot? And what can we do for district judges to stop saying this?
Not in my experience, Your Honor. And in fact, most of the cases we cite, with the exception of a 2016 case, are from the several years, 3 to 5 years.
Right, Booker is a long time ago now.
Right, and so most of the cases are from that time period. There was a period of time in the early 2010s where some district courts, in light of this court's precedent, were making statements about whether they thought, in light of the standard of review and how this court was dealing with outside of the guideline sentences, that they were being forced back into the guidelines, and that compelled some statements or goaded some statements by district courts that this court thought suggested the court felt bound to apply a guideline sentence. But I'm certainly not aware of more recent cases, and I think, as you said, given the entire context of the sentencing transcript here, we think it's quite clear that the district court understood its discretion to depart or vary downward from the guidelines.
Great, thanks, go back to it.
On the burglary issue, I want to emphasize that the district court, that first, although Mr. Glover objected to the PSR's conclusion that he had committed a burglary. His objection, which is on page 90 of the record, didn't actually specifically object to any of the specific factual findings in the PSR. And that's important as with respect to Mabry's consent, because although his testimony at the sentencing hearing perhaps put into dispute Molden's consent, I don't think there's anything in the record that demonstrates that he clearly objected under Terry and made the affirmative showing he needed to put into doubt Mabry's own consent. So I think the question at the sentencing hearing was whether Molden had given him consent. And I'd emphasize that the district court was able to evaluate the credibility of the competing testimony about the circumstances that day from Mabry and Glover and about their own individual interactions with Ms. Molden that allowed the district court to make a credibility determination about which version of events it
Can I go
believed.
back to the Molden issue just for a minute? Do you have anything other than what strikes me as a very ticky-tacky waiver argument?
I'm sorry, for the, which,
Or right, I'm having trouble with all the M's here.
yeah, the M's are complicated.
The woman, not the homeowner, not the defendant, the third party, I guess we can call her. Yeah. Do we have anything other than what strikes me as a rather ticky-tacky waiver argument?
In terms of finding by a preponderance.
Why the government couldn't have just called this woman and asked her this obvious question?
So my understanding, Your Honor, is that we, the government, didn't believe or understand that the argument from Mr. Glover would be that Molden gave him consent to be in the house. If you look at the PSR, this is on page, I believe, 88 of the PSR, Glover's statement to the police was that JM had regularly allowed him to be in the house. And then his objection, which is on page 98 of the record, just said, we object to the PSR's conclusion that Mr. Glover committed a burglary. So the government, I don't think, had any advance warning. Now,
I mean, it seems, I'm sorry, given the overall facts of this case, the homeowner leaves. When he leaves, the defendant and this woman are both in the house. Really? You're really saying the government's not on notice that he might not try to argue that the woman who also lives in the house, who was in the house when the victim left, might have given him consent? That seems like one of the most obvious possibilities in the world to me.
so we clearly thought Mabry was, the argument was going to be about Mabry's consent, again, consistent with what was reported in the PSR. But I don't think that Molden's presence at the sentencing hearing was necessary for the court to find by a preponderance of the evidence that that Glover did not have consent that day, because again, Mr. Mabry testified to his own interactions with Ms. Molden on the day of the robbery, which included seeing her asleep both before and after he left and entered the home. He also testified to the fact that a week prior to the incident, Glover had asked him to borrow the firearm and he had said no. He also testified.
That's really powerful evidence that Glover doesn't have permission to take the firearm. That's like great evidence in favor of larceny.
Right, but I think it also indicates some motive on Glover to enter the house to steal it, and I think it at least supports in a circumstantial way the district court's conclusion, specifically after hearing both Mabry and Glover testify and able to evaluate the credibility of their various accounts of their interactions with Molden.
No, Mabry actually did testify. He maybe didn't have it wasn't objected to, but he did say that was she awake when the defendant entered the residence? And he says no. And then he explains why he said no, because she was asleep when he left and she was asleep when he came back and he hit her with the newspaper. So he drew that conclusion, but nobody objected to it. There is a gap that Judge Heitens has pointed out, but it seems to me there is direct testimony that she was asleep when he entered.
I agree, and I think it does assume a conclusion. It does assume a conclusion that he did in fact enter during that period of time. But I think again the court could find that conclusion or draw that conclusion.
Can I take a step back? Does the government agree with the defendant that the burden on the consent issue is on the government, not the defendant?
So that is my understanding of North Carolina law, both based on the Mungro decision and State v. Myrick. I think that's the best I can give you, Your Honor, in terms of a clear statement, but I do think we had the burden to show that by a preponderance.
In this instance.
Yes. I'd also emphasize the fact, though, Your Honor, and I think that the breaking and entering charges is actually quite probative, at least as a circumstantial matter, for the district court to credit Mr. Mabry's testimony. I mean, the PSR pointed out that after the firearm was stolen, there was a series of text messages between Molden, Glover, and Mabry, all of which took place before the theft was reported to police, and then thereafter, police took out a breaking and entering charge. And so I think all of that, again, given that the court had the testimony live in court of Mr. Mabry, and Mr. Glover, the court could make a credibility determination and figure out which series of events it found most,
North Carolina uses sort of the modern burglary where breaking doesn't really mean breaking in any actual sense. It means like opening a door when you're not supposed to.
Yes, in fact, the statute used the disjunctive breaking or entering, and I think we cite in our brief clear case law that suggests you merely have to enter under North Carolina law to violate the statute.
This was a guilty plea. What did he plead guilty to?
He pled guilty to unlawful possession of the firearm that he stole.
How about the breaking and entering?
So there was no specific plea agreement, so there was no articulation of statement of facts at the plea hearing. He agreed that he in fact possessed the firearm, which he did, because I think there's no dispute. He took it and pawned it. But the surrounding circumstance about the breaking and entering weren't relevant to the 922 G1 charge, at least the elements of that charge.
But so on Judge Floyd's question, when there was like a factual proffer at the guilty plea hearing, there was not, he went into this place that he wasn't authorized to be or anything like that.
That's right, and there wasn't a very clear factual proffer at the hearing other than the date, which is clear from the indictment, upon which the defendant possessed the firearm. The only other point I wanted to make, Your Honor, is to the extent that there's a concern about the district court's finding here, which counsel didn't raise, but I think it's quite clear that on pages 53 to 55 of the joint appendix, that's the kind of colloquy that the government gave right before the district court overruled Mr. Glover's objection. The government went through the facts both in the PSR and from Mabry's testimony and the reasonable inferences that can be drawn therefrom to show that there was not consent for Mr. Glover to enter the home. And it was after that colloquy that the district court overruled the objection. So I think the court could find by a preponderance of the evidence, perhaps not the perfect evidence, but preponderance of the evidence and the competing testimony at the hearing that Mr. Glover in fact committed a robbery. I'm happy to answer the court's questions on any of the other issues that were raised in the briefs.
Thank you, Mr. Knoll.
Thank you.
Mr. DeSimonone.
Thank you, Your Honor. I want to make 4 points. First, as to what the government just said in terms of how we did not object, we only objected to the legal conclusion and not the facts, and that is just not true. If you look at page 98 of the joint appendix, the objections, paragraph 8, which is the factual recitations, it says, the defendant objects to the recitation of facts as to what happened on or about March 13th, 2020. That's the factual objection. He admits to possessing the firearm. However, he contends the firearm was not obtained as a result of him breaking and entering Mabry's house. So that's the legal. So we both contested the facts and the law. I also want to point out, we don't really know why Mabry thought Mullen was asleep. If he heard no sounds from that separate part of the house, it's totally reasonable for him to infer she was asleep. And it doesn't appear he was aware Glover slept over with Mabry. There's just no testimony about that. But even if you wanted to somehow infer...
He did testify that she was asleep, and he woke her up when she came, and she was asleep before he left. And he makes the conclusory statement she was asleep the whole time.
Right. I mean, he didn't testify that he checked the rest of the house. This is, again, his next-door neighbor, a regular guest, and Mullen's, significant other. I do want to make a couple points. One about the Roger Singletary, 2 points about the Roger Singletary, actually. I think the parties in court probably assumed that the district court was talking about the operative standing order when it named a particular order.
Actually, the court named SO8.
Yes.
And I was going to ask this question. It seems to me everybody sort of conceded there's a problem there. My real question, if we were going to explore that, is SO8 was a standing order that was no longer operative, but it did include that condition. And the court incorporated SO8 when the standing order, I don't know how many months before it had been changed, but SO5. Right. And of course, the condition was deleted from that. But my question would have been, can't the court incorporate a standing order that had been around for a long time and just changed a few months before and refer specifically to SO8?
The problem is it was 5 months before, and there's only ever one standing order in place at one time, right? So
No, that's all legitimate.
in terms of in the parties' minds, like when this happens in court, right, that's what they assume, and that probably it was just a slip of the tongue. They probably didn't realize it.
I think this judge is a very experienced judge, and I think he had been using the standard orders for years, which were SO8.
The other problem is,
So while it's probably, had he been conscious that there was the new standing order, we might have had a different scenario, but he did explicitly refer to SO8, which had the condition.
the problem is you
My
also.
only question is whether that would be sufficient information to tell the defendant the conditions of his.
No, because there was no notice, and that's the problem because of what was in the.
SO8 was a notice.
And if you look at the court's website, you can't find it. You have to know the exact URL to put in or do a Google search for it, but you can't find it from the district court's website.
My clerk said he found it right away today.
Right.
My question is, what was the status when it was within a few months of when there was a changeover?
Right.
The question is whether they were both up. And
Do not believe they were, and just if I could have
there's nothing in the record to suggest.
one more minute to just make one final point, going to Judge Heighten's question. I urge this court to, in terms of the Booker, I urge this court to look at United States versus Mendoza. That case involved the very same district court judge and the very same government arguments as here, that the sentencing transcript as a whole, right, showed no Booker error because the district court elsewhere referenced Booker, said that the guidelines were advisory, and analyzed the 3553A factors. But this court rejected those arguments. It said that, the defendant's reading of the transcript that the district court felt bound was, quote, at least as plausible to us as the government's reading, that it was not, so it reversed. And I urge it to do the same thing here. Thank you very much, Your Honors.
All right. Yeah, that's all right. Okay, thank you. We'll come down and greet counsel and then proceed on to the next case. And Mr. Bernhardt, whenever you're ready, we'll hear from you.
Thank you, and may it please the court. I'm Brian Bernhardt, and along with my colleague Matthew Learberg, we represent the appellant George Haddon. This case involves sentence enhancements, but in a larger sense, it's about government overreach. The law requires the government to follow certain rules in order to enhance a sentence. But when as here, the government cuts corners, it fails to meet its burden. Over the course of this case, in the draft PSR, in the final PSR, and at sentencing, the government has shifted around 5 different alleged predicates to support 2 different sentencing enhancements. But there is at most only 1 predicate, and the government therefore is not entitled to any enhancements. We request that this court find, as a matter of law, that the alleged predicates for Michigan felonious assault, North Carolina common law robbery, North Carolina second-degree kidnapping, and 1 of the 2 Michigan drug offenses do not qualify as either ACCA predicates or career offender predicates, and remand the case back to the district court for resentencing without regard for those alleged predicates.
Counsel, have you figured out what the guidelines range would have been if your client was classified as neither a career offender nor an armed career criminal?
The guidelines range would have been about 50%. The count 3, which was enhanced to a 15-year minimum, would have been a 10-year maximum. So when you go to the guidelines range, it would have, instead of being 20 years that he received, the guidelines range would have been closer to around 120 to 150 months. so roughly about 50%, maybe a little bit more than 50%.
We got 152 to 172, but I guess either way, I take your point. It would have been substantially less no matter what.
Yes, sir.
And what about if he were just a career offender but not an armed career criminal?
In this case, if he was just a career offender, the district court made it clear that he would apply the same sentence. That's why in this case, we believe that instead of there being 5 predicates, there's only 1 predicate at most, and therefore not a career offender.
Knock it down to just 1 rather than knocking it down to 2.
Yes, sir. With regard to the Michigan felonious assault charge, the question is whether it's a violent felony. And the question underlying that is whether it has as an element the use, attempted use, or threatened use of force. And the law requires us not to look at the actual facts of what happened that are set forth in the PSR, but the elements of the crime, Michigan felonious assault. Those elements, according to Michigan law, are assault with a dangerous weapon with the intent to injure or place a victim in reasonable apprehension of battery. That third element is broken down in other Michigan cases to require forceful or violent touching. And that's broken down to mean the use of physical force against another person so as to harm or embarrass another person. And it's this or embarrassment part that is the crux of our argument. The question here regarding whether this statute constitutes a violent felony does not require there to be any kind of touching. There does not require minimal touching. There does not require violent force. Instead,
But you have to put all the other elements. This was analyzed in some depth by Michigan's in the Sixth Circuit, and the Sixth Circuit analyzed this in some depth and concluded it was a qualifying offense. And the question, I suppose, is while we're not bound by the Sixth Circuit decision, they're on the scene, and if it's a reasoned opinion, wouldn't we be entitled to follow that?
this court can choose to follow the Sixth Circuit opinion in U.S. v. Harris if it likes. However, there are two issues with that case. The first, that case never talks about the or embarrass part of the law. It goes through the elements. It ignores the definitional definition.
Basically what you're arguing is, I mean, its holding was that it qualified, the offense qualified, and there are a lot of criteria for reaching that as to how the normal enforcement is, or how it's understood, the fact that there are other elements involving a deadly weapon or whatever, specific intent. These all play into it, and you focus on one little possibility, which is just literally impossible to conceive with all the elements that I've tried to conceive it. And I know you have that fraternity or sorority example, whatever. But it seems to me, if we find the court rational, Michigan's not in our circuit, and we do look at North Carolina state cases regularly and assess them under our federal statutes. But here we have a fairly detailed, reasoned opinion that addresses this very issue, and it seems to me the reasoning was pretty persuasive, I must confess. We're not bound by it, as I said, but go ahead and make your arguments. It's all right.
Yes, sir. It was a reasoned and detailed opinion, but the reasoning and the detail completely ignored the or embarrassment part of the statute. The requirement to be convicted.
It didn't ignore it, it quoted it.
It did not. It in the part of the case where it was discussing the elements, it left out the part about harm or embarrassment, and it's made a conclusory statement that because a dangerous weapon was used with the potential for harm, therefore this statute was a violent felony.
It's a dangerous weapon with specific intent to harm. Now the question is, sure, there may be a fallout of embarrassment, but you still have those other elements overriding. They're actually necessary. So you can't isolate one term. You have to look at all the elements of the statute and see whether it creates a violent felony.
Yes, sir. And if you look at all the elements of the statute using embarrassment instead of physical harm, you can conclude that a defendant can violate the statute by using a dangerous weapon to make another person fear the use of physical force to become embarrassed. And that's the part of the analysis that the Sixth Circuit did not look to. They did not take into account that you could make the person fear the use of physical force to become embarrassed. And we're required.
Deadly weapon.
I'm sorry?
With a deadly weapon, right? This isn't just assault in general. This is assault with a deadly weapon. So the hypo you have to posit is that I use or threaten to use force in a way that causes a person to fear physical harm or embarrassment. But under this statute, I have to do that with a deadly weapon.
With a dangerous weapon, yes,
Dangerous
sir.
weapon, sorry.
And there is a case, People v. Webb, that came out last fall in Michigan. It's a different statute. It was an assault against a prison guard, but the language that had to be satisfied in order to convict that defendant also required the use, attempted use, or threatened use of force. And so the court in that case went through the same analysis that I'm going through here regarding
That statute require a dangerous weapon?
That statute did not require a dangerous weapon, but the portion that I'm focusing on is the use of force. I acknowledge there was that there's a dangerous weapon in this case, but I want to focus on the force part because the force is what relates to harm or embarrassment. How did you use the dangerous weapon? Did you use it with the intent to use physical force so as to harm, or did you use it to embarrass? And if you used it to embarrass, then it's not a violent felony because you can make another person fear the use of physical force to become embarrassed. And because there are these two different options, either one of which could have been the case, we're required to look at the one that is the most innocent conduct. We don't look at the PSR to see what actually happened. We don't look at facts to see what actually happened. We look at the elements.
We do have cases under the ACCA, including our relatively recent decision in MAC, that once again says, yes, we do have to look at the language, we look at the elements, we don't look at the defendant, but there is at some point also a limit at which we look at fanciful hypos of when people cannot show that anyone was actually prosecuted for something like this. So there's tension in our precedent. I agree with you, we do not look at what your specific client did, but we also do have cases saying there is a limit to the fancifulness of the hypo that we will entertain under this approach, right?
Yes, and I have two responses to that, and I'll try to be quick because I do want to discuss some other matters. One is People v. Webb, where the prisoner spit on a prison guard, and the same language that we're talking about, forceful and violent touching. When the court analyzed that forceful and violent touching, it did so within the context of embarrassment. That court in People v. Webb didn't focus on physical harm because it was spitting. They focused on how spitting could cause embarrassment, how it could cause injury to pride, and that's the grounds that they determined that violent force had been used because of the embarrassment. So there is a case that talks about embarrassment. Second, to the extent that we're looking at, is it realistic for this to happen? I would posit that, excuse me, in United States v. Taylor, the Supreme Court undermined the undermined the realistic possibility test somewhat, noting that the defendant does not have to prove the government's prosecutorial habits, and that the test requires looking at the facts of the crime, but we're not supposed to look at the facts of the crime. So I think that realistic possibility argument is undermined somewhat.
So can I turn you then to a different question of the
Yes, sir.
result? So let me just make sure I understand this. You agree that the two drug offenses are qualifying, and your argument on those, though, is that they're potentially not on different occasions. But you agree that standing alone, the drug offenses are qualifying, right?
Yes, sir. Our argument is that the government has conceded, in fact, that they are not two occasions.
No, sure. But yes. I guess when you sort of began your argument saying, given the district court's statement, you've got to knock out all but two. You've got to knock out all but one.
Yes.
So, but one of those is going to be one of those at minimum, one of those is going to be one of the drug offenses.
That is correct.
Okay. And let's bracket away the two drug offenses. So then why isn't the easiest way to decide this case that, say, the second one is North Carolina robbery, which this court has held is a predicate?
Correct. The reason is because the government not only waived that argument, they expressly disclaimed it during sentencing. If you look on page 49 of the joint appendix, the government actually stated it didn't believe it necessary in this case to use common law robbery as a predicate because it was relying on other predicates, including second-degree attempted kidnapping, which on brief it has conceded. So the government—
I think it was necessary at the time because at the time this court had said it's not, right?
Correct. Having said that, even though the government only needed 3 predicates to get an ACCA enhancement, it still argued for 4. So why not argue for 5? They could have done that. In fact, they could have argued for more had they wanted to.
They could have asked the district court to do something that under existing Fourth Circuit law the district court couldn't do.
Yes, they could have asked.
Sure, but they know what the result would have been. The district court would have said, nice try, I can't do that.
Correct. And as it would have turned out, Stokeling had already been decided. The judge made it clear that he didn't believe that Gardner was still good law. And in fact, shortly thereafter, this court decided Gardner.
Judges don't get to anticipate our overruling one of our own cases.
Understood. But that doesn't mean that the government could not have still argued for it and then expressly preserved it for appeal. Instead, they expressly disclaimed it and said, we don't need it. And when you disclaim under U.S. v. Harper, a 2016 unpublished opinion of this court, when you expressly disclaim, then you cannot use it later on.
So on JA 48, doesn't the court pretty clearly say they think the government is preserving the argument? So I'm quoting what the district judge says. And then I feel confident that Ms. Partain is going to preserve a Stokeling argument with respect to whether Gardner survives, but Gardner says what it says. And then literally on JA 49, Ms. Partain says, and as to 25, you're exactly right, we would preserve an argument concerning the validity of Gardner. How is that not preserving it?
We don't think that that's sufficient. We discussed that in our brief. It was the court.
It would help your case much better if you weren't making frivolous arguments. I mean, when somebody says, I'm preserving this argument for appeal, and the whole explanation is why, because Stokeling put it into doubt, you say it wasn't preserved, it's sort of absurd, isn't it, on its face?
We don't believe so, Your Honor. We believe that it's the court that suggested it. It's the court that wanted to preserve it, and the government simply agreed. The government never affirmed.
What's wrong with that? The government says we are preserving it. Now, could it have been any clearer?
Yes, sir. We believe it could have been.
So what should they say? We mean it?
The government could have, during the colloquy discussing Gardner and Stokeling and whether Gardner was still good law after the decision in Stokeling, could have said, we believe that common law, we believe that that we believe that the predicate is valid and we'd like to preserve an objection on that point, instead of letting the court do the work for them. This is a very easy box for the court to check.
It wasn't the court preserving it. It was a dialogue between the parties, recognizing that Stokeling had put our prior opinion in doubt. And of course, that was confirmed shortly thereafter by Dinkins. But they didn't have that foresight. But the fact is that issue was being preserved. That was discussed back and forth, and the government confirmed, yes, we're preserving that argument.
But at the same time, Your Honor, the government
You're arguing that they didn't preserve it. Now,
and that's because...
Doesn't that sound... All right.
And Your Honor, I understand what you're saying, but we believe the language on page 49 of the joint appendix where the government says it did not believe it necessary to argue for common law robbery in this case is a disclaimer of it.
The government says we want to preserve that issue for appeal, and you say because it wasn't made clearer, we have to construe now that the government waived that issue. Is that it, or forfeited?
We think that it's questionable whether the government did actually preserve it, given its language elsewhere, saying that they didn't believe it necessary in this case, and we believe that's
It may not be necessary, because there are other offenses. I mean, on the ACCA, there were at least 4 offenses that were being seriously considered. Maybe the 2015 common law robbery. You have the potential for 2 drug offenses. You have the 2001 Michigan assault. All of those were in play. And the court, I think, ultimately, well, it sounded to me that the Michigan assault and the 2 drug offenses are the clearest myself, but the common law robbery, you had that discussion.
Yes, sir. And if I may talk about the 2 Michigan drug offenses, it appears to us in the July 25th Rule 28J letter that the government has in general conceded that the district court committed error based on Wooden. The government did claim in that letter that we did not raise, that appellant did not raise the issue. But if you look at the transcript, the sentencing transcript, the appellant did raise a objection to the drug charges. It was under a different legal theory. They argued under U.S. v. Brandon that the drug quantity wasn't sufficient. They did.
I thought the only issue there is on different occasions. It was 2 weeks apart.
Yes, sir. It's 2 weeks apart, and at the time, the district court thought that that was sufficient because it wasn't, that legal issue was not discussed.
The court suggests pretty strongly in Wooden that that's sufficient.
Well, the Northern District of Virginia last fall would suggest otherwise. There was a case tried to a jury where the drug offenses occurred in 2005, June of 2013 and October of 2013, and a jury in the Northern District of Georgia determined that that all took place on one occasion. This is a 2-week period, and we believe that at a minimum, the case ought to be remanded for a jury decision on whether it's one occasion or 2 occasions. It's certainly possible that a jury in the Eastern District, North Carolina, would come to the same conclusion as one in the Northern District of Virginia. So this is an issue that was raised by appellant under a different legal theory than we're arguing now, but it was certainly raised. I see my time's coming to an end. If there are no further questions, I'll preserve. Thank you.
Thank you, Mr. Bernhardt. Mr. Coleman?
Good morning, Your Honors. May it please the Court. Ross Goldman for the United States. I just want to start by answering a question that Judge Heitens asked. As we calculated, if Mr. Haddon were neither ACCA nor a career offender, I believe his guidelines range would be 92 to 115, based on a base offense level of 23 and a criminal history category of 6.
That's if you take both of them.
If you take both of them out, yes. And I believe your other question involved if he was not ACCA, but if he was a career offender, and I believe his guidelines there would be the same, 262 to 327 under 4B1.1C3. So I just wanted to answer those questions at the outset. As we explained in our answering brief in this case, there are 4 ACCA predicates.
I didn't quite understand that response. If you took both enhancements away, what would be the range?
As we calculated, it would be 92 to 115.
And then if you had
plus the consecutive 60 on the 924C.
If you had just the career offender, what would you have?
262 to 327.
So he was sentenced at 240.
Correct. As we explained in our brief, there are 4 ACCA predicates. The statute only requires 3. There are 3 career offender predicates when the guideline only requires 2. So even if this court were to have doubts or invalidate one of either, the sentence would still be legally correct.
A procedural, sorry, I taught procedure for years. A procedural question about the North Carolina robbery. Is it a problem that you didn't cross appeal on that issue? Did you need to cross appeal?
No, I think it's very clear under Supreme Court precedent that an appellee does not need to cross appeal if they're not seeking to change the judgment. Then there's no need to cross appeal.
And in criminal cases, the judgment is the sentence. That is the
correct. It's the judgment of conviction. We are asking for this court to affirm, and so there's no need for the government to cross appeal to ask this court to affirm on a basis that the district court did not rely on. It's it's the principle that this court can affirm on any basis supported by the record.
And was properly. Any basis supported by the record and properly raised before the district court, which we had a colloquy there, but yes.
Sure, and I think, as the colloquy, I think, made clear, and as we made clear in our 28J letter on this, I think it was completely preserved. Everyone understood that the question was whether Gardner survived Stokeling, and, the government's position was it did not. That's the position this court ultimately took in Dinkins. And so I don't think there's any real question, and there's certainly no dispute now that the predicate qualifies. The dispute is whether this court is entitled to treat it as a qualifying predicate based on the record, and we think there's rather obviously is the case that this court can. On the Michigan assault predicate, assault with a dangerous weapon predicate, counsel on the other side focus on the or embarrass language, and I think the easiest way to respond to that is to remember that the ACCA does not care about the ultimate reason why a defendant attempted to use or threatened to use physical force. There are some statutes that do require proof of a motive. The ACCA is not one of them. And so to sort of play off of the sorority hypothetical, if a fraternity brother were to hold a pledge at gunpoint and say, you have to go to class with blue hair and blue makeup over your face because part of pledging is to be embarrassed, but does it at gunpoint, the use of the gun is the threatened use of physical force. It doesn't matter that the pledge ultimately didn't want to hurt, that the fraternity brother didn't want to hurt the pledge, but rather wanted to embarrass him. The ACCA doesn't care about the why. The ACCA cares about whether there was an...
Judge Sutton explained that. He actually quoted the embarrassment language from the Michigan cases and concluded that it's the force
that was threatened there and went through it and said it qualifies.
That's exactly right. And it's very similar to, and we cite the First Circuit decision in Wendleton, which held that the Massachusetts assault with a dangerous weapon statute, which is in all material respects the same as Michigan's, also qualifies as an act of violent felony for the same basic reason.
I guess in the gun, I'm not sure the gun hypo is the really tough hypo for you, because in that instance, although my aim is to embarrass you, not to harm you, I'm still using the gun in its gun-like capacity to threaten. Like, if I point a gun at you, the implicit threat is I will shoot you, and that is unambiguously physical force. Like, I'm trying to imagine a world in which I'm using a gun, but like not as a gun, right? I'm using a gun. It's difficult to do this in a way that's like appropriate for this setting, but like you could imagine some sort of novelty theme gun that is being used in a way to like sexually embarrass somebody or something, but I'm not threatening to you know what I'm saying? Like, what do I do with that kind of hypo?
So two answers to Your Honor's question. One is, and it does relate to something that counsel on the other side said, there's no reasonable probability that the statute would be used that way. Taylor does perhaps cast some doubt on reasonable probability as applied to federal predicates. The court's very clear in Taylor that, but not as to state predicates. And Mr. Hedden has never come up with a case, we've not found a case where this kind of, Your Honor's hypothetical is posited. But then more as a legal matter, I'm not even sure that would qualify as a predicate under the Michigan statute. What use of a dangerous weapon means, and this is quoting from Harris, is any object that is used in a way that is likely to cause serious physical injury or death. So if there is some kind of mock gun that everyone knows is a fake gun and no one knows and no one thinks that the gun is going to be used to hurt anybody, then arguably that gun is not actually being used. And I don't think you'd have the Michigan predicate in that case. But I think the insight that Judge Sutton drew for the Sixth Circuit in Harris and that the First Circuit drew in Wendleton is, and this is the differentiator between assault as a general matter and assault with a dangerous weapon, is that the use of the dangerous weapon at the very least will categorically involve the threatened use of physical force. And that's why—
Back to your Taylor point, what would be the basis for having a different rule for federal and state predicates? I mean, I understand the Supreme Court in Taylor is talking about federal predicates, but why would we have a different rule?
So what the Supreme Court talked about in Taylor was, it sort of located it in federalism concerns, that when a federal court is interpreting the bounds of a federal statute, that there's no need to, or there's perhaps less of a need there to wonder about how a federal court might or might not allow a statute to be applied. But when you're considering a federal court's treatment of a state court in a state statute, that there's some amount of deference that has to be applied. It's not fully spelled out. Certainly this court has continued to apply reasonable probability. That's an important point, I think, in this litigation. It's not the feature point. I think the feature point here is that there is just no way to violate this Michigan assault with a dangerous weapon statute without, at the very least, categorically threatening or attempting physical force.
Let me preface this by saying I have no idea if I don't think it matters here, but I'm just curious. So my understanding is, in terms of the drug offenses, it is now the government's position that these are Apprendi facts that have to be proven to. If the question is whether I did something on different occasions than the other, that is now an Apprendi fact according to the government?
Yes.
Okay. So in other words, so then why wouldn't it have been plain error here to use both of the drug counts? Again, I don't think the district court needed to use both of the drug counts, but assuming for the sake of argument, why isn't it plain error to have used both of the drug counts?
So several responses to that, Your Honor. First, we brought the department's new sort of Wooden position to the court's attention because we thought it was consistent with our obligations to the court. Having said that, we don't think that the Sixth Amendment Wooden issue is actually in this case. It's not something that Mr. Haddon has ever raised, either in district court, in his opening or reply brief, or even in response to our 28J letter. And in fact, in his 28J letter, where he points to the recent jury verdict, he uses that as evidence that the district court plainly erred in finding that these, as a factual matter, that the offenses occurred on separate occasions. So we don't think that the Sixth Amendment issue is in this case. Even if this court were to conclude otherwise and think that it is, at the very least it would be, or at most I should say, it would be reviewed for plain error. In that respect, we would concede prong one. We would concede that there was error because in the government's view, this is something that is either something that a defendant has to admit or a jury has to find.
It's not clear and obvious because—
It's not clear. The error is not clear and obvious because this court held in Thompson in 2005 and then reiterated in Daniels post-Wooden that, in fact, this is a matter for the district court to resolve. Every circuit before Wooden every circuit's law was to the same. And so the
But it may also be that it hadn't been fully resolved. Wooden didn't resolve the issue.
Wooden explicit.
And Almendores explicitly said 924E is a recidivism statute that is a sentencing fact, not goes to the court.
Correct. So Wooden.
We don't need to get into that, I don't think, here for the reasons explored by Judge Heitens, but
I agree, fully agree that the court doesn't need to get into that. But just to answer Judge Heitens' question, I mean, in Daniels, which was post-Wooden, the court sort of said that it was bound by Thompson in rejecting the.
No, we just came out with the decision in Moon, which is post-Wooden, and held that it's still a sentencing fact that doesn't go to the jury.
So that's why there would be no clear and obvious error. To finish out the answer to Judge Heitens' question, to show an effect on his substantial rights, Mr. Haddon would have to show that if he knew that this was something that a jury was going to have to find, that there's a reasonable likelihood he would not have pleaded guilty. You know, relating back to my first point that this claim is not in this case, it's not a showing that he's ever tried to make. So that's the sort of answer on to Your Honor's question about the Sixth Amendment aspect of the Wooden claim. On the merits, the drug convictions were 2 weeks apart. There's no dispute that Mr. Haddon engaged in the conduct underlying those two convictions 2 weeks apart.
Were they at two different locations? We don't know, or do we?
We don't know. We don't know.
I tried to find it. I couldn't see.
Yeah, it was the same drug to Michigan State police officers 2 weeks apart. This court's pre and post Wooden case law, as well as Wooden itself, I think makes, and this court has said post Wooden, it was outcome determinative that offenses were committed weeks apart from each other. The Northern District of Jury.
Wouldn't acknowledge that the most common differentiator is a day apart.
Correct.
And seemed to suggest that that was a very strong indicator. And here we have the 2 weeks.
2 weeks apart.
Of course, that doesn't lessen the message of Wooden, which is a factual question.
That's right. And indeed, letter low, the offenses were an hour and a half apart. And this court said they were committed on different occasions. And this court.
But I think in Wooden that would be, we would have to relook. Maybe,
but I would only make the point that in Daniels, this court said that letter low is consistent with Wooden. And so, but again, I think.
Which, to be fair, was unpublished.
It was. So the court is not bound by that. I mean, Justice Gorsuch, in his concurring opinion in Wooden, noted that letter low was consistent with the majority in Wooden's sort of more holistic understanding of what constitutes different occasions. But basically on any metric, I think the district court was right that these were committed on separate occasions.
That it?
It is. Thank you, Your Honor.
Thank you. Mr. Bernhardt?
Thank you. Just a few brief points. I agree with my colleague that ACCA doesn't care about the reasons why, but ACCA does care about the possibilities. And one of the possibilities is the use of physical harm to embarrass. Now, if we're only going to say that because there was a dangerous weapon, as a matter of law, this is a violent felony, then it raises the question, why do we have, with intent to injure or place victim in reasonable apprehension of battery, which when defined down, comes down to using physical force against another person so as to harm or embarrass? Why would we imagine that the Michigan courts are imposing an element that's not required? They did do that. So simply because there's a dangerous weapon involved is not determinative. This statute cannot be violated without a dangerous weapon.
If you read the opinion in the Michigan cases that are cited in Harris, they cite that embarrassment. They also cite the requirement of physical force and what that meant and the intent, specific intent in that case. They cited numerous elements and came to the same conclusion that this was a real proffer of physical injury, of force. And the consequence that it results in embarrassment as opposed to injury was overridden by all the other elements that have to be demonstrated. And that was explicitly explained.
And I would note, Your Honor, that this court, as has been mentioned, is not bound by the Sixth Circuit. And there are other examples where U.S. v. Taylor, for instance, where we did not agree with other circuits and were proven to be correct by the Supreme Court. I would posit here that the Sixth Circuit analysis of the Michigan statute was incorrect because it did not take into account the embarrassment requirement.
It did. It recited it, it quoted it. And then it said in the next paragraph, in light of all the elements, and it emphasized that.
It did, Your Honor, but when it recited the facts and discussed the facts, it did not address embarrassment at all. The court, you are absolutely correct that the court recited all the law, and in that recitation of the law noted harm or physical harm or embarrassment, but then it completely ignored the embarrassment prong in making its conclusion. And we would posit that if you ignore the embarrassment prong, that the case is decided wrongly. The last point I'll make, if I may, is regarding the drug charges. It's been repeatedly stated that 2 weeks is sufficient, but I would again point out that it was 13 years apart in the Northern District of Georgia where the jury decided that it was one occasion, not two or not three.
Hard to give us much help because we don't know what the facts and circumstances were, what was said, what was done, how it was done, how it was charged, what the investigation consisted of, and we have a jury that's instructed and not making the determination of the significance of the facts that were set forth in.
May I have additional time to answer that question, Your Honor? That is true, but we also lack those facts in this case. In this case, all we know is that they took place 2 weeks apart. So if we only know they were 13 years apart, it's the same. Thank you very much.
Thank you, Mr. Bernhardt. I notice you were court appointed. Is that right?
Yes, sir.
I want to express our appreciation. That's a genuinely important service to the court. It makes the system work, and your client can appreciate that you handled this well for him.
Thank you very much.
All right, we'll come down and greet counsel, and are you okay to proceed on that? United States versus Brown and Mr. Carpenter. Hear from you.
Thank you. May it please the court. This case presents two questions. The first is the merits question, and the parties now agree that constitutional errors occurred in the proceedings below. The second issue is whether those errors should be disregarded as harmless, and we contend that under this court's precedent, the answer is no. Now, although the government concedes on the merits, I do want to start with that issue to give the court an opportunity to ask any questions it may have given the somewhat unusual posture of this case. Our view, in short, is that the combination of Wooden and Mathis means that the occasions clause must be alleged in the indictment and then proven to a jury beyond a reasonable doubt or admitted by the defendant as part of the guilty plea. Because that did not happen here, the proceedings violated Mr. Brown's Fifth Amendment rights and his Sixth Amendment rights. The combination of these two cases abrogates this court's prior decision in Thompson. And so I think the best way to illustrate that is through what I think is a fairly simple syllogism that combines Mathis and Wooden. In Mathis, the Supreme Court says the prior conviction exception in Almendarez-Torres extends only to the elements of a prior conviction. Then, in Wooden, the court says the occasions clause requires consideration of facts and circumstances that go beyond the elements of the prior conviction.
Well, as to Thompson, aren't we bound by that precedent at this time because the Supreme Court has not issued in the intervening time anything that directly undermines Thompson? So you know the rule, Mr. Carpenter, that a panel of this court can't overturn the precedent.
I certainly do, Your Honor, and let me start by saying, if you feel bound at the end of the day, let's take this en banc, let's do it in May, because we have a bunch of cases in the district court waiting for this. But let me explain why you don't need to do that. The reason you don't need to do that is because although Wooden does not address the issue specifically, it does not make a holding on the Sixth Amendment, that is not necessary to trigger this court's intervening authority exception to the panel precedent rule. And as an example of that, I would highlight the recent decision in United States versus Reed that was issued on February 1st of this year, so just last month. It's 58 F 4th 816. In that case, the court recognizes that the Supreme Court's decision in Concepcion undermined a part of this court's holding in Collington. In doing so, Reed says, look, this case, Concepcion, involved a different issue than the one that was in Collington, so it was not, quote, expressly overruled. However, as Reed explained, the Supreme Court's language was, quote, broad and clear, and that made the prior holding in Collington untenable, even though it was on a slightly different issue than the one decided by the Supreme Court in Concepcion. That's the exact same circumstance here. I acknowledge that neither...
Not, quite. Let me take you through how I see this as a little different, and I think it's not our cases that are the problem. I think it's Almendarez. And as you recall, in Almendarez, the court addressed specifically ACCA 924E and concluded that that was a recidivism provision.
Your Honor, if I could stop you very quickly. Almendarez-Torres was not about ACCA. It was about the aggravated...
It cited ACCA and
may have cited
ruled right on it, and it held that ACCA was a recidivism. And it said the recidivism issue is not related to the conviction, it's related only to sentencing. It said the fact that recidivism does not relate to the commission of the offense but goes to the punishment only, and therefore may be subsequently decided. And it cited 924E, and it explained that the whole provision was that. Then comes Wooden and says the second prong of 924E is a factual question that has to be resolved. Then comes our case in Moon, and Moon cited Wooden and said that 924E was a recidivism statute that doesn't relate to the merits, and said that it is only a sentencing issue. This is post Wooden, and so you would have us overrule Thompson, Moon, and Almendarez, I think. And it seems to me this is an issue. Justice Thomas has raised the issue you raised, and I think it is a Supreme Court question. But I'm not sure we're free to move in the direction you want based on Wooden. Wooden clearly says it didn't decide the issue, and I think in view of Almendarez, it is still a sentencing fact. The question is, how does it have to be decided? Thompson said, will you use the Shepard documents, and even more clearly in Moon, more recently, we said 924E does not go to the jury. It's a sentencing fact. It's a recidivism fact, like Almendarez said. I respectfully suggest that you make a lot of good arguments, but to require a circuit court to send recidivism facts to a jury would require the Supreme Court to step in and address Almendarez and its extension of Wooden. How are we going to find those facts? And it seems to me all the quotes you take are from the finding of a predicate offense. That's one element of 924E. But the next element is they have to be on different occasions. And Wooden says that's a factual question. And so that leaves the underlying courts. How do we resolve that? And your argument is that should go to a jury. which is, I think, can't be squared with Moon and Almendares. You say somehow we can get around that. I can't see it. But it seems to me if they want to take recidivism facts and make it part of the offense, that's a big change, and that would have to be the Supreme Court to do that, wouldn't you think?
No, Your Honor, I very strongly disagree with that. And let me start with Almendares-Torres' point, and then I do want to get back to Moon, but the Almendares-Torres point seems to be really the core of your concern.
Well, it goes on pages. I didn't quote it all. It goes on pages talking about how recidivism is not a part of the offense. Recidivism, and they said since colonial times, has been a sentencing fact.
So, Your Honor, what I would respectfully suggest is, just as you suggested that all of the language I quote is about the prior conviction part and not about the other part, all of the language in Almendares-Torres is likewise about the existence of a prior conviction. And as Wooden makes clear, there are two separate statutory conditions in Wooden. In ACCA. There is the 3 occasions and the 3 convictions. We are not disputing.
So if you think that's what Almendares says, you're going to split up 924E, which has 2 conditions now, 2 clear conditions. One a prior
That's exactly
conviction,
right.
and
Yes.
the other is on different occasions. You're going to say the prior conviction is done by the
Yes.
court, and the other one's going to be done by the jury?
Yes. We think that, now we would
Yet,
like,
even though 924E has been categorized as a recidivism statute, that doesn't go to the offense?
no, again, as Almendares-Torres has been subsequently clarified and explained by the Supreme Court, it goes only to the existence, the simple fact of a prior conviction.
That's to establish a prior conviction.
And we acknowledge that this
They
court,
did not address what Wooden addressed.
correct, this court is 100% bound by Almendares-Torres on the existence of a prior conviction. We can argue all day long that should be overturned. We can argue that prior
Or
convictions.
even Apprendi. Like, I'm literally thinking about every single decision of the Supreme Court since Apprendi. It's always phrased this way. Other than the fact of a prior conviction, comma,
Yes.
anything that increases the defendant's sentencing range has to be submitted to a jury, right? It's always other, that, I mean, I realize there's language in Almendares-Torres that goes broader, but the way the court has described Almendares-Torres in every decision since Apprendi is other than the fact of a prior conviction, comma, right?
Exactly. And what Wooden tells us and makes very clear is that ACCA's recidivism elements, there are 2 separate recidivism elements. There's one, the existence. We acknowledge that's controlled by Almendares-Torres. But the second condition.
The fact of a prior conviction is, I have a document that says on date such and such, defendant Bill Smith was convicted of robbery in violation of Michigan. That's the fact of a prior conviction?
Exactly, that's it. And what the Supreme Court has clarified in Descamps and Mathis is this exception in Almendares-Torres extends to nothing more than the what crime and what elements the defendant was previously convicted of.
Possibly the date of the conviction?
Possibly the date of the conviction. I would note that even if you consider that fact in this
Not the date
case.
of the underlying offense, but the date of the conviction.
Yeah, the date of-
22nd, 2021, you were convicted of the.
Exactly, and I think that is an important point to separate the date of the conviction from the date of the underlying conduct, because everything about the underlying conduct that goes beyond the elements cannot be found as part of the prior conviction exception. So,
How do you handle Moon? We explicitly said 924E is an enhancement and not a separate offense, and is decided as a sentencing enhancement.
that's correct, Your Honor, and what I would point the court to.
And it referred to Wood.
Absolutely, and it cited Thompson approvingly, I acknowledge that.
Thompson's earlier, yeah.
But isn't 841 USC B1A also still an enhancement? I mean, even after Apprendi, the jury has to decide drug quantity, but I don't think we say B1A as a separate offense, is it?
It's an enhanced offense.
Right, but it's not a separate.
Exactly, it's lesser included and greater offense. Like that is how that works, that is how this works. It's an enhanced offense.
We've called it a different offense, and the elements have to be, when it relates to the conduct at hand, if you say we're going to distribute drugs, it's one offense. If you just say we're going to distribute 50 grams or whatever the quantities are, it's a different offense, and we've explicitly held that.
Well, I think that's yes. I think we're violently agreeing here. That is so I'll leave it at that. As for Moon, what I would point the court to are the back-to-back decisions last year in Simmons and then in Banks, because we are in the same setting as those cases. So in Simmons, the panel of this court said we feel like we have to apply the rule of Floresca It was an in-bank decision by this court, and no one has challenged its validity, even though we think it's questionable. We are going to apply it as it stands because no one has challenged it. A few months later, the government took the cue, challenged Floresca, and in banks, the court said, now that they've challenged it, we're going to reconsider whether it's viable, and found that it was not. That's exactly what we have here, because if you go back and look at Moon, no one challenged the validity of Thompson. That wasn't the issue presented there. No one argued the intervening authority exception.
Let me ask you something a little more fundamental. The qualification that the offenses need to be on different occasions, that is a description of recidivism, right? Part of the recidivism thing. It has to be, recidivism is punishing somebody because they had prior offenses on different occasions, right?
Yes, as a general matter.
So the whole aspect of 924E addresses recidivism, right?
Correct.
So now the question is, do we have any case where the recidivism aspect of a case is part of the actual offense committed, or is a separate offense that has to go to a jury?
This is the first, and it's because the Supreme Court has narrowed.
You're arguing that recidivism is an element, this aspect of recidivism, you have two elements, one prior offense, conviction on separate occasions. You're saying that at least the separate occasions part, which is factual, has to be decided by a jury.
Correct.
Because recidivism ought to be decided by a jury.
Correct. The other scenario where
Now,
this...
Justice Thomas agrees with you.
Well, to be
But
clear...
I'm not sure the rest of the court is there yet.
Well, I think if you read Justice Gorsuch's footnote, he's there. But setting that aside, I would highlight and emphasize that the Supreme Court does not talk about the recidivism exception to the Sixth Amendment. They talk about the prior conviction. And I do think there's...
But you lose the forest for the trees. In other words, 924E is a recidivism enhancement. It's not an enhancement based on conduct in the offense. It's based on prior conduct, which is not on trial. It enhances the sentence, and the one element, it has to be a prior conviction that qualifies, or several and the other, the prior convictions have to be on different occasions. But that's all definitional for recidivism enhancement. And my question is, we have to face the fact of what recidivism is in connection with a crime. If it's part of the offense, and a court could make that, I think it would be very dramatic. If it's not part of the offense, which is traditional from colonial times, but is an enhancement for sentencing, then we just go on, and Wooden is not remarkable. It just basically says the second element of recidivism is a factual question, and the question then is who resolves the facts. And if recidivism doesn't go to the jury, then it would be the court.
Your Honor, I agree. This was what you've articulated was the understanding of the law that everyone had, from Almendarez-Torres, basically until Decomp and Mathis. Those cases, we contend, have narrowed that understanding. But I want to get to your other question about whether we have any other case or example where some component of recidivism is submitted to the jury. And you don't have a case on it because the government concedes this issue and has been submitting facts to the jury since the first, in a different context. So
the question is whether we accept the government's concession. I mean, what we have here is a case deciding which is going to influence other cases. We have to get the statute right, number one. Number two, the government briefed it that way. I thought did a pretty good job. And just recently, the Solicitor General has said, we think part of the recidivism ought to go to the jury.
Sure.
Well, I don't understand that analysis at all.
Yeah, let me back up and clarify what I meant. I was talking about an entirely different context, which is when the First Step Act amended the definition of a serious drug offense under 841, it added to the recidivism inquiry there a couple of factual questions. One is whether the prior offense was committed within 15 years of the current offense, and the other is whether the defendant served 12 months or more on the prior conviction. Those are factual matters. They're part of recidivism, but they are factual. Since that time, in 2018, the Department of Justice immediately issued guidance saying these are facts. They're not inherent in the fact of the prior conviction. We have to submit them to the jury. The jury verdict that we submitted from the Northern District of Georgia, you'll note, has two questions. One is the ACCA question, and then on the second page, there is an 841 enhancement question, which asks the jury to find this separate set of facts. So again, the government's conceding this because the Supreme Court precedent, we think, when you combine Wooden and Mathis, it requires these types of recidivism-related, recidivism-adjacent facts to go to the jury. I see I'm beyond time. If there are questions on the harmless error component of this, I'd be happy to answer them. Otherwise,
We'll let you take that up on rebuttal if you have.
Sure thing. Thank you.
If you choose. All right, Ms. Wright.
Thank you, Your Honor. May it please the Court. Anthony Enright for the United States. We agree that the Sixth Amendment requires a different result than the result reached in Thompson, but I do want to correct something my friend said in his brief, which is we didn't withdraw our brief in this case. And the reason is simply that the district court, like us and like a panel of this court, is bound by this court's precedent. And for the reasons this court explained in Daniels and in Baston and in Moon, Thompson and Letterlow and Wooden are consistent with one another. Wooden didn't abrogate Thompson, so this panel.
Let me ask you what your views on this are. I understand all these formulas we're tossing around. How do we do the categorical approach, the modified categorical approach? How do we resolve 924E without having new trials? That's all been the subject of numerous Supreme Court cases, and I suggest thousands of lower court cases. And we've been litigating this now for 20 years and been trying to figure out how to determine these prior convictions without retrying them. And that jurisprudence keeps developing, and I think Wooden is just a further step in it, which is still trying to determine this 924E. My question is a little bit broader and asks a little more question. 924E, everybody recognizes, is a recidivism statute. It enhances a penalty because somebody's a recidivist, a repeat offender. And to qualify as a recidivist, you have to have prior offenses, convictions, and you have to have prior convictions that are different on different occasions. But they both address recidivism. You agree with that?
I do agree with that, Your Honor.
So now the question, the underlying question is, setting aside all the cases, does the government take the position that any aspect of recidivism now consists part of the conduct on trial before the court, or is recidivism remain sentencing facts that are decided after trial?
Our position doesn't turn on what qualifies as recidivism. Our position turns on what qualifies.
I know, but I'm asking you about recidivism.
Certainly, Your Honor. Some
I've said-
components of recidivism are going to be for the jury, and some components
That's why I'm understanding why, because it's not part of the conduct in the case. The conduct in the case is the crime on trial. The 924E doesn't address that. 924E says if you had prior conduct that qualifies, we're going to enhance.
That's true.
And so my question is, where was that ever suggested that those facts of the prior conduct should go to a jury with respect to the present conduct?
And I think Judge Hyten's question answers that, which is the Supreme Court has, since Apprendi, said the limitation of Almendarez-Torres is to the fact of a prior conviction. There's a broader universe of things that qualify as recidivism, but the Supreme Court has limited the Almendarez-Torres exception to specifically the fact of a prior conviction. And in Mathis and Discamps,
But they were just addressing, in all those cases, they were just addressing how do you establish a prior conviction. Just establishing a prior conviction. The issue of on different occasions was never presented in those cases as a question.
That's a very...
So they were resolving how to resolve, and they said Almendarez says you just go to the fact of conviction.
Yes, Your Honor.
But Almendarez says more. It says the whole statute is a recidivism statute, and it's not for the jury. So now we face for the first time, following Wooden, we face for the first time the second component, which is on different occasions. Supreme Court says that's a factual question.
You're reading...
The open question now is when there's an open factual question on recidivism, because you conceded it's part of the recidivism statute.
I agree.
I think you have to.
I do.
Who decides that? And I think at this point in time, no court has said that, and yet our moon court suggests that all of 924E is a sentencing enhancement and cited Wooden.
I agree, Your Honor. Your reading of DeCamp is a reasonable reading of DeCamp, and it's the position we took for several years, and it's the position this
I
court
thought your brief was pretty persuasive.
outlined in Span. I appreciate that, Your Honor. And that is why I think this court is bound by its precedent. This court has held that when
Is the government, I thought the government's position is that the district court erred.
the district court properly followed
Did not
this.
file a letter saying it is now the position of the district court that the district court erred.
It is the district court I can't answer it fully because the question is, I think the district court violated the Sixth Amendment, but I think the district court properly followed this court's precedent. So the court did what the district court ought to have done in this case because the district court was bound by this court's precedent like this panel. But I do believe it's an error under the Constitution that this court ought to correct, if at all, en banc.
Do you agree the Sixth Amendment does not cover sentencing facts?
The Sixth Amendment does not govern sentencing facts if they are the fact of the prior conviction.
I didn't ask you that. I said any sentencing fact. If we categorize something as a sentencing fact, do you agree the Sixth Amendment doesn't require that go to jury?
A fact found within the statute that determines what sentence to apply within the statutory maximum, I agree with that. If it's a fact that increases the statutory maximum and it is not a fact of a prior conviction, then the Sixth Amendment does govern it. So that's basically our position. And the reason I think this court is bound by its precedent is because of what Judge Niemeyer described, is that that's a reasonable interpretation of Supreme Court precedent when there's tension under Dodge between the Supreme Court and this court. You ask whether they can be read harmoniously, this court's precedent and Supreme Court precedent, and as Your Honor pointed out, they can. And has this court relied on it? And it has since Mathis and his camps, and even since Wooden, has relied on Thompson continuously. So I think this court is currently bound by it. Different question en banc, of course. I do want to turn to the harmless error point because that's another question that's clearly resolved by this court's precedent. Leggin says, is the evidence establishing the sentence enhancing factor overwhelming and essentially uncontroverted? It is overwhelming because...
I'm looking at your 28J letter. Your 28J letter does not preserve an argument that there's no error. You say, as explained in the brief, any failure to submit the occasion was harmless. You say that it is now the position of the government that the Sixth Amendment required this to go to the jury, and then you say he's not entitled to relief, but the reason you say he's not entitled to relief is because it was harmless, not because there is no error on this court's precedent. So are you now making an argument the government did not make in its 28J letter?
I do apologize, Your Honor, because I don't know that I disagree with Your Honor. My answer was just trying to clarify what our position is. I believe that the district court was bound by this court's precedent.
Wow, because that is not in your 28J letter.
That is correct. I don't think I said that.
The only argument in your 28J letter is there's a harmless error here. That's the only argument that you said.
I was not presenting an argument in the 28J letter. I was trying to inform this court of the Solicitor General's position, and I apologize because obviously your question indicates that I was not clear enough, and I humbly apologize for that.
Your position is you wrote your brief and advocated affirmance, and then the Solicitor General has changed its position, and you did not withdraw your brief, but you tried to recognize that now you have to advocate the Solicitor General's position, which is that the facts of 924E, second prong, have to go to the jury.
Yes, Your Honor, absolutely true. And the reason I'm not trying to preserve an error, Your Honor. If this court were to find that the court should have required a jury to find these facts, and it should have been in the indictment, that's ultimately our position. I feel bound to recognize that this court and the district court both were bound by this court's precedent. So I'm super sorry for being unclear, but that was not my intent. On the harmless error point, which is in our brief, and I hope I preserved in the 28J letter, Leggins, overwhelming evidence, because the different occasions here, we're talking about different dates, months and years apart. And yes, there's probably some theoretical world where you could identify different days. I don't know about months apart, but some different days where you could plausibly have it, but I think this still qualifies as
So
overwhelming.
assume that we don't think the pre-sentence report is evidence. What is the evidence that these were on different occasions?
Well, if you don't, the pre-sentence report on its own, perhaps not, but it would be the fact that the court adopted it as its finding of fact after the district court, after the defense didn't object to it, which is its prerogative under 32. If this court ignores the pre-sentence report entirely, including that adoption, then there's nothing, because this wouldn't be before the district court in any form, as far as I know.
I guess what I'm trying to figure out, like, the more common, a common scenario where when the Supreme Court's talked about the classic Apprendi problem is where we have a jury verdict. I basically guess what I'm saying is it's never been entirely clear to me how Apprendi harmless error analysis applies in the context of a guilty plea. So I understand how it works in trial, like take Johnson or take Nader, right? So we have a jury, we present all the evidence to the jury, but we don't instruct the jury on materiality. And then we ask, sure, we didn't ask the jury to find materiality, but based on the evidence we presented to the jury, it is inconceivable that a jury would not find materiality. Well, it's inconceivable that a jury who convicted this defendant without the materiality instruction would have not found materiality. That's basically Nader, right? I get how that works, and I get how it works in the context of a forfeited Rahafe error where the burden is on the defendant to show substantial rights, to say, like, have you made any proffer whatsoever that you would have possibly argued that you didn't know you had a qualifying conviction? So that's right how Greer says we do forfeited Rahafe errors. But I guess I'm trying to think of a case of Supreme Court, maybe that's the threshold question. Are you aware of a Supreme Court case that talks about how you sort of do harmless and error analysis on an Apprendi-type error in a case that was a guilty plea?
Not directly, Your Honor. I'm aware of Nader, though, and Nader does say that the harmless error standard considers the record as a whole. And so I think this court, it's appropriate to look at sentencing. It obviously, I think it is not appropriate to do what I think the defense suggests, which is just look at what was presented to the jury at trial when you have a guilty plea, because there is no trial by definition, and that would convert it to
when Nader talks about the record, it's pretty clearly talking about the trial court record. For example, just imagine an Apprendi-type error that happens at trial, in a jury trial. There's a jury trial. Okay, let's take drug quantity, for example. That's the classic case. We don't submit drug quantity to the jury. The jury finds the defendant guilty of distributing an unknown quantity of a controlled substance, and there's no evidence at trial about how much he distributed. The government presents zero evidence about how much cocaine. And then the pre-sentence report says, wow, it was a lot of cocaine. And the government then argues it's harmless error that the jury didn't find drug quantity. We wouldn't look at the PSR in that situation. We would look only at the trial transcript, right?
I don't know that that's plausible. All of these cases do seem to come up in a trial.
Right.
And
it's
this
hard
really,
to figure out how it applies in a guilty plea context.
I know of one. I don't remember if it was a guilty plea or not. I know of the Ninth Circuit, which follows the same overwhelming and uncontroverted standard. They looked at the sentencing, at evidence introduced at sentencing in a case called Zepeda-Martinez, 470 Fed 3rd, 909, not the longest opinion, but it's an example of that. And what I would suggest is, between the court saying the record as a whole and the fact that the sentencing gives a venue for the parties to contest it, the defendant has an incentive. The defendant has an opportunity to say, I dispute that fact, and I'd like to introduce some evidence at sentencing. And that's really the opportunity to do that in a guilty plea proceeding, unless there's some unusual situation where you're pleading guilty to something and going to trial on another.
But assuming that this is one of the problems with the nature of the Apprendi error, right? Assuming the violation is I had a right to have the jury decide it, saying I would like the judge to decide whether I win on that claim is not really a remedy to the violation that the wrong person made this decision, right?
It's not a remedy for it, but it is an indication of whether it's a harmless error. It doesn't, the idea isn't it wouldn't undo the error, but it would allow the court to say the result would have been the same even if this had been in the indictment and had been submitted.
Another step beyond Nader, right? So Nader itself is 5-4, and Justice Scalia says this is hypothesizing a jury verdict that never happened. You know the argument Justice Scalia makes in the dissent in Nader. This is like another level, right? Because at least when a defendant is sitting in jail because a jury of his peers found him guilty, it's because a jury of his peers found him guilty. When a defendant is sitting in jail because of a guilty plea, he is only in jail because he stood up in front of a court and he admitted things, right? That is the only justification for incarcerating someone who pleaded guilty is the thing he admitted. And it's a little troubling to say, we're gonna go back and decide he actually admitted certain things he didn't admit because we think it's harmless that he didn't admit those things.
That's something the court pointed out in Liggins, not in the context of a guilty plea, but it is, there is a discomfort judges have expressed with that. I don't think it's a greater discomfort than exists in a trial, and in fact, I think the fact that he admitted it, well, in this context.
I mean, after all, we require district courts to have a really long colloquy before people plead guilty. Like, here's the following list of like 25 things you're giving up by what you're doing here. That's
exactly right, Your Honor, and what's critical here is he had notice. He had notice at the guilty plea that, well, if the Armed Career Criminal Act applies, that's going to be your penalty.
How did he have, in what sense did he have notice?
We told him.
Okay, he was at me, so he not notice in the abstract, like you know the law notice. Like
No, he was informed. The penalties, if the Armed Career Criminal Act apply, are 15 years to life, and he said, I want to plead guilty. If you don't have that, that's another kind of error. This court has recognized that in Lockhart. So
never told the defendant he could get sentenced under the
right. If he was not aware of that penalty, that at least in Lockhart, the issue was that would be vacated. Nowadays, if you adopt
maybe I think Judge Heitens raises a very significant question, but maybe the answer might be when he pleads guilty and recognizes that ACCA will be applicable, he doesn't just, and that waives the jury trial, because he explicitly waives a jury trial in pleading guilty. That's one of the questions. Do you know you have a right to a jury trial and you're going to waiving that? Maybe the implicit thing is that he's waiving it also as to ACCA.
That may be true, Your Honor.
If ACCA was to be decided by the jury. Now, of course, the language, it doesn't fit perfectly because he's advised that it's a sentencing factor as opposed to an element of the offense. But
yes, Your Honor.
But I'm just trying to provide some fodder for the notion that maybe his guilty plea does cover the waiver of the jury trial, even for ACCA facts.
That's not something we're relying on, because I think you could still.
I know you're not, because nobody anticipated it.
It does, however, I think it raises a point about fairness. What he did have was an opportunity to contest these facts. It's truly undisputed. If he thought these occurred on different occasions, he could have made that argument. He said, I'm objecting to paragraph 23. That's the conclusion about the Armed Career Criminal Act. He did not object to paragraphs 29, 30, and 33 in the PSR, which are the dates.
This is just largely a backwards-looking problem, right? Because I assume going forward, the government would have required him at his plea colloquy to admit these were on different occasions?
Yes, regardless of the outcome in this case, that is nationwide marching orders, Your Honor.
So basically, as part of any guilty plea, the defendant.
Oh.
Sorry, go ahead.
I might have misunderstood. Our marching orders are: if you want the ACCA, you put it in the indictment.
You put it in the indictment, and then if the defendant pleads guilty, you put in the indictment. If it's a jury trial, you ask the jury to decide it, and if the defendant pleads guilty, you ask him to admit the different occasions at the plea colloquy.
Correct. And if that doesn't happen, we don't ask the district court to apply the ACCA. Now, sometimes the district court says, "Well, I'm bound by Fourth Circuit precedent, and I'm aware of these convictions, so I will," but we don't ask for that, and we do put it in the indictment and seek a jury trial on it. So I do think it is there's this
limited universe of cases that it will affect.
Correct, Your Honor. I want to just address briefly some of the other issues the defense has raised. This isn't a constructive amendment, both because the defense says it's not a constructive amendment and because the court in Whitfield distinguished the Apprendi cases, which Higgs is one, from constructive amendments. It's kind of a fine distinction, but if the distinction doesn't exist, then this court is bound by the Apprendi cases. And the court held that in Higgs that the Apprendi indictment error is subject to the same harmless error standard as the jury finding error, so it's all governed by Rekowenko. Information and sentencing counts, we talked about that. If this court has, trying to think if there's anything else, because it seems like there's a lot, but.
We have a lot to chew on.
What's that, Your Honor?
Thank you, Mr. Enright.
Certainly.
All right,
Appreciate it, Your
Mr.
Honor.
Carpenter.
Thank you, Your Honor. I want to start with one point about the recidivism issue that we were speaking about, Judge Niemeyer. I think a different way to look at it is we agree that everything under the enhancement is recidivism related. So there are two components. There's the existence of the prior convictions, and then there's the occasions. And so I think we also all agree that when we're looking at the existence, the Supreme Court has placed a limitation on what judges can look at. They can only look to the elements. And so that same limitation must also apply when we're looking at the occasions. And so if you apply that to this case, for example, what we see is there are 2 robbery offenses where he was convicted on the exact same date in state court. So if we apply the Descamps-Mathis limitation to this case, we end up only with 2 predicate offenses. ACCA needs 3. The only way that we can get to the ACCA sentence in this case is by going beyond the elements, going beyond the existence of the prior conviction, and considering these other facts.
I hear what you're trying to do, but you're collapsing the inquiry because you still, even if the 2 are together, you're still going to have to establish the elements of the conviction and the fact of conviction to have it qualify. Then you have the additional requirement, which doesn't relate to whether the conviction occurred. It relates to whether it's on different occasions. And both are required for the recidivism.
Agreed.
And then you have to go back to the original Taylor case, original Supreme Court Taylor case, where they talked about this problem, categorical approach, and focus on why we are doing that. And the reason we are focusing that narrowly is we don't want to retry the cases and we don't want to interfere with Sixth Amendment implications. And so we go for the conviction and fact of conviction. Then we find that sometimes that doesn't work too well, and we made a little exception for Shepard and limited Shepard documents. We're still not interfering, we don't believe, with Sixth Amendment when we do the Shepard documents, and it allows us to determine whether a prior offense qualifies. Now we have a new thing, which are whole new facts, which have nuances that have to be found under Wooden, and that's a new problem. But that's not the fact of conviction which these cases established, and it may not raise Sixth Amendment problems. It may. If it does raise them, then the answer might be to use the Shepard documents, limited. But that hasn't been addressed, and my whole point was that the discussions in all these cases that refer to just the fact, and they categorize just the categorical approach, just the fact of conviction and the elements, and I agree with all that, but I think the court all along was focusing only on satisfying whether there were qualifying offenses. And so now we have the different occasions. We sort of played by ear, and we're very liberal on it. The courts were in accepting different occasions, and the Supreme Court says you can't be so.
So I think the response I have there, Judge Niemeyer, is that there can't be 2 separate Sixth Amendments. So if there is a Sixth Amendment problem with a judge making inquiry 1 by going beyond the elements, then there is likewise a Sixth Amendment problem if on inquiry 2.
Sixth Amendment problem is retrying the earlier case, interfering with the jury verdicts, and getting into a retrial, which is also a practical problem of the earlier case. But on different occasions is a different problem with respect to the convictions. And on different occasions, it's a more limited factual inquiry, I suggest, number 1. And if it is a Sixth Amendment problem, I can't see how it is, but if it is a Sixth Amendment problem, then it's resolved by the Shepard documents. That would be the approach that we would have to create at this point, because nobody's addressed this following Wooden.
Your Honor, my point there would just be that the Supreme Court's language in Descamps and Mathis is broader than you are giving it credit for.
I think address the different occasions.
But certainly, but it also does. They are clear in those cases. And I agree with you in Taylor and Shepard.
That's the handle they give to it. They start with Almendares and they give the handle to it, starting with Taylor, saying you just do the elements of conviction and the fact that you were convicted. That gets around all the problems of establishing, but they still recognize that as a sentencing enhancement. And the sentencing enhancement was just element of it. Anyway, I understand your position. I think you understand my questions.
I do. Let me add before I know I'm running a little low on time here, but I do want to make just one very quick point about the harmless error issue and the overwhelming facts.
Pretty dicey point too, isn't it?
And I think the point I want to highlight for this court that I haven't had a chance to say is it's very important to distinguish the context of sufficiency review and harmless error beyond a reasonable doubt review. If this had been submitted to a jury and they had returned a guilty verdict on the occasions, we would not have any viable argument that the evidence is insufficient.
Well, I understand it comes down, basically, the court decided it as opposed to the jury.
Correct, but
in this case, you have a September 14 offense, you have a July 14 offense, and then you have a 2013 offense 6 years later. So these offenses were different contexts, different times. I mean, to me, factually, there's no question they're on different occasions by the standards under Wooden.
Again,
but the real question that comes on harmlessness, can we jump over, if we believe it has to go to a jury, can we say it's harmless? And I think that Judge Hyten's raised those questions. I think those are dicey.
Right, and I think the point I would leave the court with on that is while we agree that the separate dates might be enough for a sufficiency or clear error review, the standard here is harmlessness beyond a reasonable doubt, that no reasonable jury would find that the other Wooden factors, such as common scheme or purpose, the relationship between the offenses, point in the defendant's favor. And I think that's where the Northern District of Georgia jury verdict that we submitted on Wednesday shows that even where offenses are separated by a significant amount of time, when a jury is properly instructed on the Wooden factors, they do sometimes reach a decision that might be different than what we, on a cold record, would reach.
That decision is because they had a left-handed foreman.
Possibly.
You see those checks in there?
I did see those checks. And he was consistent, though. He did it in both of the checks. But our point is that a reasonable jury could think that the other Wooden factors point to this being a single occasion and could acquit on that. That's why the harmless beyond a reasonable doubt standard wouldn't be satisfied if it is the correct standard. Thank you.
Thanks a lot for your arguments. This is a very interesting exchange. We'll come down and greet counsel and proceed. Are you okay to go to the last case?
Yeah, I'm ready. You go to the last case.
All right, we'll proceed to go to the last case after we come down. And Ms. Coleman, whenever you're ready, we'll hear you.
Thank you. Good morning, Your Honors. May it please the Court, Megan Coleman on behalf of the appellant Rodney Kobe. The conviction at issue in this appeal is Mr. Kobe's conviction for distribution of a controlled substance resulting in the death of Angela Bailey. Mr. Kobe contends, first, that the government failed to prove that the fentanyl distributed was the but-for cause of death, and alternatively failed to prove that the fentanyl was an independently sufficient cause of death. Second, it's our contention that the district court improperly instructed the jury that it could use a Pinkerton theory of liability to find Kobe liable for the death results enhancement of count 5, without any mention in the Pinkerton instruction that the jury must find that Kobe was part of the chain of distribution. The sentence is also at issue in this appeal for two distinct reasons, one of which I'll focus on here today. The district court violated the ex post facto clause of the Constitution in applying a sentencing enhancement that was not in effect at the time the crimes were committed, and therefore improperly increased Mr. Kobe's guidelines from a range of 360 months to life to life to life. And it's our position that that was error that substantially affected the rights of Mr. Kobe, and that this court should exercise its discretion to correct that error. With respect to the first issue in this appeal, it's our position that the government failed to prove beyond a reasonable doubt that the fentanyl in this case was the but-for cause of death. This case is unique because here the medical examiner, Dr. Allen, never testified that but for the fentanyl taken by Bailey, that Bailey would have lived. Instead, the evidence in this record shows that Bailey could have died absent the fentanyl, either from DPF or from fentanyl.
I understand it's conventional to shorthand the statute as saying dies as a result of the fentanyl, but don't we go back to the statute that doesn't actually say the fentanyl, it says a mixture or substance containing the fentanyl? And so isn't the actual question whether he died as a result of the mixture and substance containing the fentanyl, whether then he died from the fentanyl?
Your Honor, I understand that in this case it was charged.
Well, that's also what the statute says.
And the statute as well.
Right.
I think that doesn't change the analysis. The reason being, we still don't know what the mixture was that killed Angela Bailey. And
so let me just make sure I get this. So imagine that I sell someone something I tell them is heroin, but for some inexplicable reason, I also cut it with a large amount of arsenic. And they take it, and they die, they ingest this mixture or substance I gave them, and they die. And it's clear they died because of the arsenic. I think under the statute, I'm still liable under death resulting, right? Because even though arsenic is not, assuming arsenic isn't a crime, you see what I'm saying in that hypo? In that hypo, I think I'm still liable, right?
I do see what you're saying, and I think it causes me to have to address the three potential theories of DPF in this case. The first being that DPF could have been a precursor to the fentanyl, and that would, I think, align with the hypothetical that you just gave, that, well, what if the arsenic was mixed in with the fentanyl or with the other substance, and it was thus part of the mixture. The second theory of DPF in this case was that it was a metabolite of fentanyl. And then the third theory was, I would submit, really just a theory, never endorsed fully by medical reports and never endorsed by any of the experts in this case, which was that DPF could be possibly a very minor metabolite of the use of fentanyl itself. Let me start with the first incident of whether or not DPF was a precursor to the fentanyl.
Why is this whole analysis necessary? In other words, we have a bunch of circumstances where the allegation is that Kobe sold her a mixture containing fentanyl, and that death resulted. We have this, these various related chemicals to fentanyl. It's not a case where it shows up that she died of arsenic. It shows up she died from some aspect of fentanyl, maybe a precursor, maybe a metabolized version of it or whatever. And her urine tested positive for fentanyl, which is interesting to me because the urine is the more recent sampling event than would be the blood. And nobody made a big argument about that. But you go back to the circumstances of the whole event. She was buying drugs. She was dependent on Kobe. They made an arrangement. They met. They're put together. They don't actually see the actual transaction, but the circumstances suggest it. And a couple of hours after that transaction, a couple of hours later, she's dead. Those circumstances are very strong. And if it's possible, I mean, if my question is now the analyses of her blood don't preclude that. What they do is, you're saying it doesn't satisfy which element, which caused it. But the fact is, the only benefit you get from that is that maybe she had drugs from some other source that killed her.
Yes.
But the circumstantial evidence is so strong that that doesn't become that meaningful. She died from some aspect of fentanyl, and her urine showed positive for fentanyl. And with the other circumstances, parsing it to figure out the chemical, which chemical feature, where did it come from? Was it a precursor, or was it a metabolite of it, or was it a separate chemical? And you make a lot of it, and I understand it. You would like to have a perfect match so that the resulting would have to be closer. But This gets to the basis of the statute, which is you distribute drugs and it results in death.
And so, Your Honor, with that, what I would say is I think that that's what the importance is in this case. It is not just that Ms. Bailey used fentanyl, even if the fentanyl did come from Mr. Kobe. What's important is that the death resulted from the mixture containing the fentanyl that Mr. Kobe distributed. And here...
She did die concededly, didn't she, from intoxication?
She died from a combination, which Dr. Allen was specifically
Fair enough.
pressed.
So we know it's a drug death. She
Yes.
didn't die from a heart attack. She didn't die from aneurysm or something else.
I agree. She died from a drug.
So
She died
now
from
we
drugs.
have, she receives drugs from Kobe, by inference, of course. By
course.
inference, they communicate, and she's addicted, and she needs these drugs, and they meet, and she gives him drugs, and 2 hours later, she's dead. And not only that, purportedly, he sold her fentanyl, and we have residues of fentanyl in the things about her, were in the paper and of her, and we have fentanyl in her urine, and we have this crazy mixture in her blood. So the question is, he distributed fentanyl resulting in death. Did he distribute fentanyl resulting in death? And the jury comes back and said yes. And I'm wondering what other conclusion in those facts could you reach?
You could reach the conclusion here because Ms. Bailey was found at the scene of her death. There was a spoon containing fentanyl. The toxicologist testified that DPF is a metabolite of the use of fentanyl, and therefore the presence of DPF indicates that fentanyl could have been ingested. We also know that no DPF...
But the question is, let's say it was ingested, and it was from, it was part of this chemical mixture that was given by Kobe. The real question is Kobe's illegal distribution of illegal substance resulting in death. And the only question is the linkage between what he purportedly sold and what was found.
And to me, that is...
And they didn't do a chemical analysis of what he sold necessarily because, you know, you mix flour and baking soda or powder, you may test different parts, you haven't mixed well, and so it may test differently. But my question is there any other possibility that she died from drugs from some other source or some other person?
Yes.
Circumstantially?
Not even circumstantially direct, Your Honor. There was testimony that Miss Bailey was with Tina Hancock at the time of her death. Tina Hancock was a fellow drug user who herself was under the influence of drugs at the time of Miss Bailey's death. Tina Hancock was the one that went to a stranger's house and asked them to call 911. There was a 2-hour window that had passed between the last contact between Miss Bailey's cell phone and the phone number attributed to Mr. Kobe, and then the actual time of death of Miss Bailey. So we know in that 2-hour window that she was with another drug user who also was under the influence. Now, we don't know what that other drug user was under the influence of. We also know that when the government executed the search warrant in this case, and there was more than 200 grams of fentanyl discovered.
You're talking about 6 weeks later or 2 months later?
It was months later.
That's irrelevant.
Well, the government has not established that Mr. Kobe ever distributed a mixture containing DPF as a precursor to fentanyl or fentanyl, yet we know from the medical experts in this case that DPF intoxication alone could have been a cause of death. If there had not been fentanyl in the system, DPF intoxication standing alone would have sufficed. And that's different from what we've seen in other decisions in this circuit. In the Robinson case that the government included in their 28J letter, there, even though the medical examiner never testified that the fentanyl was the but-for cause of death, there was no other evidence in the record that any other substance could have caused the death. Additionally, factually, the decedent died within 5 minutes of snorting the fentanyl. This, I would suggest, is a set of circumstances that is more similar to the Burrage case by the Supreme Court, where you have a combination or a contributing cause, but it doesn't rise to the level of but-for causation, and it has not been established that fentanyl on its own was an independently sufficient cause of death.
But the Pinkerton issue. So let's start by saying, I think you have a difficult potential argument on preservation, and I think you have a difficult potential argument on the merits, because I'm not overwhelmingly persuaded that the Sixth Circuit's decision is right. But let me ask the more what I think is the heart of the question, which is, even assuming it's preserved, even assuming that you're right in the merits, why doesn't the special interrogatory on JA 1141 say any error here was harmless when the deputy clerk says, did the government prove beyond a reasonable doubt that the use of fentanyl distributed by the defendant, Rodney Mundell Kobe, resulted in the death of Angela Bailey? And the foreperson says yes. Why doesn't that indicate that even if there was a problem, any error is harmless? Because the jury made the very finding the Sixth Circuit said that a jury would have to make.
The argument that I can make here is that you have to look at the jury instructions as a whole, not just count 1 versus count 5 instructions. And so by saying that the special verdict alone is sufficient for this court to know that that's why the jury came to the count 5 conviction that it did, it ignores improperly, I would suggest, what was told in count 1, which was that you don't have to necessarily be guilty of the substantive offense. You don't have to have personally committed those acts or been part of the chain of distribution. So long as you find that he is guilty on count 1, you can, and the other factors that are part of Pinkerton liability, that's enough. And there was no instruction that if you're going to apply Pinkerton liability from the conspiracy, that you still have to find that Mr. Kobe was part of the chain of distribution. And so I recognize that the jury was told that it had to go through this checklist in the verdict and check off the counts of conviction, but the jury was also told that you don't have to find Mr. Kobe directly responsible for count 5. You can also find him guilty of count 5 if you find that he was a member of the conspiracy and you find him guilty there. I recognize that the Ham opinion has not yet, it's been cited by a lot of other cases within the same circuit, within the Sixth Circuit where it's upheld the reasoning of Ham. I recognize that no other federal circuit has yet referred to Ham. Ham was only decided in 2020. What I would just like to say about why I think that the Ham's reasoning is persuasive.
I'll just say what I find most questionable about it is that it seems to rely on the sentencing guidelines to interpret a federal statute, which seems to me, with all due respect, completely upside down and backwards.
And I recognize that that would be a potential weakness that this court might look to. And so let me just offer this potential analogy for your honors to consider. In this circuit in Irvin in 1993, this court held that the district court had to determine that the quantity of narcotics was reasonably foreseeable to each individual co-conspirator prior to determination of the applicability of the mandatory minimum sentencing provisions. It rendered this holding notwithstanding that the plain language of Section 846 provides that any person who conspires to commit an offense in 841 shall be subject to the same penalties as those prescribed for the object of the conspiracy. So the importance of the Irvin case is that it recognized that notwithstanding that Congress said if you are a member of the conspiracy, then you're going to get the same penalties as a substantive offense, the Irvin court went on to say at page 75, rather than automatically rely on the quantity which would enhance the sentence, the court must determine if it's reasonably foreseeable. The sentencing provisions should be individualized to reflect a particular conspirator's relative culpability in the conspiracy. And the Irvin court even found some support for interpretation of the statute within the sentencing guidelines. It says that at page 77 of the opinion. It wasn't controlling of the ultimate holding, but it was a consideration. And that's similar to what the Ham court said. It said even though our underlying decision in Swiney has been categorized as a sentencing guidelines case, that's not really the case. It was an interpretation of the language of 846 vis-a-vis 841 and how the sentencing guidelines also seem to narrow Pinkerton liability in the sentencing context. And I think that our precedent here in the Fourth Circuit from Irvin did a similar analysis with respect to the quantity of narcotics. Otherwise, anytime a defendant in the Fourth Circuit is convicted of a conspiracy, he would be subject to the amount of narcotics attributable to the entire conspiracy. But we know that that does not happen in the sentencing context. Let me next, if I may, move to my third issue with respect to the sentence, because even if I don't prevail with having the conviction for count 5 vacated, I do think that this is an exceptional case where the sentence must be remanded and a full resentencing hearing must occur. I don't want to presume that the court would also concede that error occurred as the government did, so I'm happy to address points 1 and 2 of clear error, but I think it is pretty well established from what the guidelines say that there is an ex post facto clause violation where a guideline enhancement is used at the time of sentencing that was not in effect at the time that the crime was committed. And here we know that the 4-point sentencing enhancement went into effect in November of 2018, and the conduct in this case was 2017 through April of 2018. It's our position that the application of an upward departure to the guidelines affected Mr. Kobe's substantial rights, which is the third prong of plain error. The Supreme Court made it very clear in Molina-Martinez at page 203 that a defendant can rely on the application of an incorrect guidelines range to show an effect on his substantial rights. The defendant does not have to provide additional evidence in a case where the court applied an incorrect range, but nevertheless sentenced the defendant within the correct range, which is what happened here. We submit that the government overlooks that the guidelines are a very real part of the court exercising its discretion in coming to the ultimate sentence. We know that case after case has said that the sentencing guidelines must be calculated properly. They are the anchor to the final sentence that is ultimately imposed. They are the framework. And here, contrary to the government's assertions, the district court did not just rely squarely on the 3553A factors in fashioning its sentence. This was an extremely lengthy sentencing proceeding where the guidelines issues were thought over by the district court, where he even took a 10-minute recess to ponder what the arguments about the guidelines were. And then the government expressly, during the 3553A factor argument, the government expressly asked that the district court, quote, sentence the defendant to the advisory guideline sentence of life. The government, quote, believes a sentence of life imprisonment, which is the guideline sentence, and no sentence less, reflects the seriousness of the offense and is sufficient to address the factors under 3553. We also know that the court struggled in reaching the final sentence of 40 years. The court was looking at whether to sentence Mr. Kobe to life, which was what the government was asking, which was the guideline sentence, and a sentence substantially less, still serious, but a sentence somewhere between 30 and 34 years. We also have precedent in this circuit that this court, on review of what occurred in the district court, must know that absent the guidelines error, the sentence would have been the same. The case law that the government cited to predated the 2016 Molina-Martinez case, and now it is quite clear upon plain error review that a defendant does not have to show that his sentence would have been lower absent the guidelines error. The only way the government can get around it, which it cannot do on the facts in this case, is if the government were able to point to areas in the record where the district court made it clear so that this court can be certain, and those are words from Fourth Circuit precedent, where the district court made it clear that it would have still imposed the 40-year sentence notwithstanding any issues with the guidelines. The district court did not make such a pronouncement, and therefore under Molina-Martinez, the defendant has established his burden of plain error review in establishing that the error here impacted his substantial rights.
All right, I think we'll take your rest. You're over, and
I apologize, and the rest, and that was how I was going to conclude. Anyway, so thank you. You cut me off at the perfect time.
But you do have rebuttal.
I do have rebuttal.
And you have a hunk of rebuttal.
Thank you.
All right. Why don't we hear Ms. Wright?
Thank you, Your Honor. Good morning. May it please the court. I am Elizabeth Wright, Assistant U.S. Attorney on behalf of the United States. As to all four issues this appeal presents, defendant Rodney Kobe's convictions and sentence should be affirmed. Turning first to the issue of the sufficiency of the evidence as to count 5, I want to refer first to Judge Hyten's questions from the beginning, and yes, the question here is whether Angela Bailey died from the mixture and substance that Rodney Kobe distributed. And responding to Judge Niemeyer's point, yes, she died from fentanyl-related causes. Everything relevant was in this singular mixture and substance that we think there is no question on the evidence presented that Rodney Kobe distributed to her earlier on that day. She died within 2 to 3 hours of the essentially known meeting with Rodney Kobe that was confirmed by the cell site location data and otherwise, and corroborated by all of the text messages. And there is no indication whatsoever in the evidence here that she had any other source of supply. So we submit that this evidence is amply sufficient, especially on the standard applicable here, to show both that Rodney Kobe was the sole distributor to Angela Bailey during the relevant time period, and that it was this singular mixture and substance that he distributed to her that killed her within hours of that distribution. The evidence to which the defense refers pertain to Tina Hancock. She was Stephen Jerome's mother, and essentially the evidence showed that that Miss Bailey and Mr. Jerome had driven up to this meeting with Kobe and had come back down to that neighborhood, but there was no indication at all, despite the defense suggestion, that she was using drugs, that Miss Hancock was using drugs at that time, that she had any other sources or anything like that.
Can I ask you about what I think is the hardest issue for you, for the government?
Please, Your Honor.
The 2D 1.1B12 issue. So just as a threshold matter, I understand the government to agree the district court used the wrong guidelines manual here,
That's correct, Your Honor.
and that's error.
Yes, Your Honor.
And it's probably clear, obvious error to use the wrong guidelines manual. For,
Ye-
under Alano prong 2.
Yes, under Alano prong 2, yes, we essentially focus simply on the effect on the substantial rights, and then the
What do I do
second.
with the fact that Melina Martinez seems to say we normally assume that screwing up the guidelines calculation impacts substantial rights?
Well, I think that there are sort of both. I think we still satisfy the test in Melina Martinez, and this is a very unique case in terms of what influence the guideline range had or did not have, essentially, on the sentencing. So we think under the Melina Martinez standard, there was not an effect on substantial rights, and the record makes that clear, and also that this is not a case where any discretion by this court should be exercised to respond to that. And the reason is that the cases where there are findings of sort of this kind of negative effect from the guideline range are cases where the guidelines range was a numerical range, and there was accordingly evidence from that record that there was some tethering to that type of numerical range. All of the cases that the defense cites were in that context where the range would say, and in—
That may be true. I'm talking about the language of Melina Martinez. Now, interesting question about how this can be squared with the way the plain error rule is written. But I guess I read Melina Martinez to state a general rule of, and this is part of what the separate concurring opinion was about, but I think the fair reading of the majority opinion is when the district court screws up calculating the guidelines, absent evidence to the contrary, we will assume that had an effect on the district court sentence, because even though Booker has happened, the guidelines exert a significant gravitational force on federal sentencing. That's the premise of federal sentencing. So when a district court gets the guidelines range wrong, we presume, and absent, this case would obviously be a lot easier if the district court had said, even if I got the guidelines wrong, I'd still give you the exact same sentence. But this district court did not say that. So why don't I properly understand Melina Martinez as saying, in all but a relatively uncommon case, I assume that when a district court screwed up the guidelines, that had an effect on substantial rights?
Well, I guess first I'll say that I think the Melina Martinez ruling was more narrow than what you're describing, Your Honor. So the Melina Martinez was reacting to a very specific and limited to the Fifth Circuit rule that required that the defendant present additional evidence of prejudice, essentially, from an error in the guidelines range. And Melina Martinez at page 203 says that its decision simply states that courts reviewing sentencing errors cannot apply a categorical rule requiring additional evidence in cases like this one, and also like the one before this court, where the district court applied an incorrect range but nevertheless sentenced the defendant within the correct range. And that is what essentially the holding of Melina Martinez was rejecting this Fifth Circuit approach. And I'll also note that
Sure, but I'm just going to read from you the end of the first paragraph of Melina Martinez, which says, absent the evidence, sorry, that's the range. I'm going to find it, but there is language in Molina-Martinez that is broader than that, right?
Right, I understand that, Your Honor. But even then, Molina-Martinez was basically saying that even though there may be...
Okay, so sorry, here we go. When the defendant is sentenced under an incorrect guidelines range, whether or not the ultimate sentence falls within the correct range, the error itself can, and most often will, be sufficient to show a reasonable probability. That is a flat-out statement of the Supreme Court in Molina-Martinez.
Yes, Your Honor. And we are saying that this is is an exception to the most cases where that will be sufficient. Because in this case, Judge Hazel did a very thoughtful, prolonged analysis under the 3553A factors and was not tethered at all to a particular guideline range. This was a case where the government asked for a life sentence. That is a sentence that is still that is not changed by any error. The defendant's requested sentence was not linked to the guidelines whatsoever. The defendant asked for 25 years, which was the mandatory minimum statutory sentence. And the court, therefore, was basically on a completely open playing field in terms of the sentence. And it very carefully exercised its discretion, and we submitted basically exactly what this court would want a district court to do in appraising this type of sentence by looking very carefully at the 3553A factors. And this was a court who had sat through the entire trial and obviously entered the sentencing hearing believing that a very substantial sentence was appropriate. And the truly only mitigating factor, and what the court cited in reducing the sentence from and disagreeing with the government's recommendation of life, was something that also had nothing to do with the guideline range, and that was the sentence received by Stephen Jerome, which had been 150 months. And the court considered that factor, which again is not changed by any guidelines error, as the factor that caused it to give a sentence that was lower than the very, very serious, potentially life sentence that was otherwise warranted. The court referred repeatedly to deterrence, to its very careful appraisal of what effect its sentence would have when it was distinguishing between sort of a life sentence and a very substantial 30 to 35-year sentence. And it imposed this, 35-year sentence based, and with its only reference point to the disparity between a sentence for Rodney Kobe and the sentence for Stephen Jerome. And I think that the court's pointing, sort of looking to the sort of the textual point, it is true in this case that the court did not make the statement that it would have imposed the same sentence no matter what. It's clear in this court's authority that that is not required. And I think the most telling quote about that is at page 12.
This court has said for a number of years now that if a district court says that, we will give that a great deal of weight, and at some point every district court judge is aware of that, and at some point, I don't think you can read too much into this, but the argument on their side is, since every district court judge knows that this court would give substantial weight if it says the words, even if I'm wrong about the guidelines, I do the same thing, you can perhaps draw some inference from the fact that a district court doesn't say those words.
Your Honor, well, I think here, I guess I quibble a bit with the premise of that. So I will say in United States versus...
Quibbling with the premise that every single district judge in the Fourth Circuit knows that if they say the words, I would do the same thing anyway.
Well, I think that they do know that, but at the same time, there's no requirement to say that. And here, we do submit that the rest of the record makes clear sort of what was implied, that this was the sentence that, based on the consideration of all of these factors, he would have imposed.
You make a fairly persuasive argument that because the guideline was life, if he's going to depart, he gets a free slate and pick the sentence based on 3553. The question I have, though, is if he's confronted with a guideline that says 360 to life, and he says, I want to create a variance, would he then go down from 360? In other words, he's starting out with a background that life is on the table, and that's the only recommended sentence, and he would have to create a variance, and he did create a variance. But if he got a guideline range of 360 to life, would he
then feel free, and did he have some desire to go further down? We don't know that. You indicate that he selected a sentence on a clean slate, and therefore this is more likely not in relation to a range, but to his independent determination of how many years the man should serve. That may be right. Incidentally, you know, Judge Hazel is no longer serving, and now somebody else would have to, if we were to order resentencing, somebody else would have to resentence him.
That is correct, Your Honor. I think the language in the sentencing transcript that I would point to that most clearly shows that Judge Hazel, that does clearly show that Judge Hazel would have reached this sentence no matter the guideline range, is at page 1282 of the joint appendix. And then after having imposed this sentence for all of the factors under 3553A that he's considered, he says, essentially as an afterthought, he sort of notes that it's a variance. So he obviously was not concerned with or thinking about it as a variant sentence at that point. He says, quote, "The sentence that I have imposed does not fall within the guideline range. It's a, I don't know, slight. The guideline range was life, so it's a variance down from a life sentence. And the court's findings generally on the 3553A factors and purposes explains the court's reasoning. But I will also specifically point to the need to avoid unwarranted sentencing disparities in this case." So he does refer back to the guidelines then as saying, and essentially as showing that he was not thinking about that and tethered to that at the time. He had been clear at the beginning of the sentencing hearing, which is at JA page 1247, he emphasized that this was not a mandatory life case. So he was very aware and attuned to the fact that life was, yes, on the table, as it will be on the table still, because the government was arguing either way, arguing for life, will be arguing for a guideline sentence in this case. But he was very clear that this was not a mandatory life case, and he referred essentially to the combined mandatory minimums, the fact that he was essentially above that range, and then the only mitigating factor that he cited throughout and relied on in the sentence was avoiding the unwarranted sentencing disparities. Because this was a case where, as Judge Hazel acknowledged, Mr. Kobe had killed 2 people, and he said he was entitled to take into consideration the death of Anthony Davis as well as the death of Angela Bailey, and the fact that Kobe had continued to distribute fentanyl after knowing, or after there was evidence that he knew that Angela Bailey had died from the use of that fentanyl. So this was an exceptionally serious case, and he was able to and looked at every single factor without any numerical tethering from the guidelines to find the appropriate sentence for Mr. Kobe. And the fact of the way he described this, and particularly that reference on page 1282 of the joint appendix, shows that this was the sentence that he believed was appropriate under all circumstances. And he also believed it was appropriate, sort of he imposed that sentence and then did go and reduce it by, so the sentence on count 5 ended up being 420 months, and then he also included in his 40-year sentence the 5 years under Section 924C that by statute would run consecutively to whatever the guideline sentence was imposed. So in that respect, also, he was not tethering anything to the guideline range. He found the appropriate sentence for Mr. Kobe. Then he did assign, he thought about it, he was reasoned about it, and he assigned the sentences by count to overall meet that appropriate sentence. So here, that is evidence, and we think fully satisfies the Molina-Martinez standard to show that this was a sentence he would oppose again, and it was not linked to what the guideline range was. I will, if I may proceed briefly to the Pinkerton argument that the court also addressed. And I think, again, responding to Judge Heitens' point, that yes, even assuming that there was error here, and whether or not it was preserved, the special interrogatory does fully resolve this question. The government does submit that Pinkerton liability in this circuit applies to both the penalty and substantive components of count 5. As the court noted, the Ham decision has been limited to the Sixth Circuit, and that, I think that saying that it was just decided in 2020 it doesn't really capture the limitation because it was explicitly based on a decision that was subtly from about the year 2000. So that principle has been around in the Sixth Circuit for quite some time and has not been adopted anywhere else. And I believe, or we submit, that this court's approach to cases under 924C makes clear that there is no distinction under Pinkerton between the substantive offenses and sort of different substantive offenses that happen to have substantial penalties. And for that, we rely on United States versus Gillespie, 27 F 4th at 941, where Judges Niemeyer and Heitens, you were on that opinion in terms of 924C. And it is also fully consistent with the approach that this court takes to sentencing for the drug weights, which similarly have very substantial penalties. We don't see any inconsistency, as defense counsel cites, between Irvin and this court's approach more generally, because for Irvin also the question for those conspiracy cases is what is the scope of the agreement? And that is what makes it relevant what drug weight was sort of specifically foreseeable to those individuals. But the rules under Pinkerton apply, and there is no exception to those based on what the penalties happen to be for the substantive offense. And that's essentially the approach that the defense is arguing for in this case. I would also say that even under the Ham decision, there would be no issue with this verdict. Again, Ham did not have a special verdict form. We do have one here. The government in its argument never referred to Pinkerton and relied fully on its position that Kobe distributed the drugs to Angela Bailey, and that is what the jury specifically found in its verdict. So looking at the jury instructions as a whole and the evidence as a whole has to include the special interrogatory that was very clearly answered at page 1141 of the joint appendix. Yes to whether did the government prove beyond a reasonable doubt that the use of the fentanyl distributed by the defendant, Rodney Mondell Kobe, resulted in the death of Angela Bailey. So again,
Well, I don't know the extent to which you can actually look at the evidence presented, but maybe you can. But the evidence presented focused on Kobe and did not suggest anybody else that Kobe was derivatively liable for somebody else's conduct in this distribution resulting in death. And
absolutely, Your Honor.
I mean, it's just totally absent. And your whole case was based on direct communications between Kobe and the decedent and the meeting and the timing and of course, the analysis.
Yes, absolutely, Your Honor. And I think the defense refers to the fact that that Angela Bailey, she was also with Stephen Jerome, but for both of them, the undisputed source was Kobe. And again, the only indication of any source of supply that appeared in this record for Angela Bailey around the time of her death was Kobe, whom she met within 2 hours of passing away from the fentanyl overdose. And if the court has no other questions, thank you.
We'll hear from you.
Thank you, Your Honors. Your Honors, I'm just going to reply with respect to the sentencing issue. The arguments that we hear from the government are exactly the arguments that governments on prior occasions have made to this court that this court has squarely rejected. In United States versus Gomez, which was a 2012 case, the government unsuccessfully contended, like here, that because the court arrived at the 24-month sentence purely through reference to Section 3553A factors, especially deterrence, that a remand to recalculate the advisory range would be a pointless exercise. The Gomez court was unconvinced, noting that although the district court did a commendable job in considering the factors in determining the sentence, we are unable to state with any certainty that it would have been the same sentence. Similarly, this court had the opportunity in Peral Dominguez, which was a 2015 case, to consider the government's arguments that the district court placed great emphasis on the 3553A factors. However, this court could not, quote, embrace the government's assertion that the wrongly calculated guidelines range had no effect on Dominguez's sentencing when it potentially took more than 3 years of a man's life, and thus the error was not harmless. The government has failed to cite a single case in this Circuit in which the district court improperly calculated the guidelines range and the sentence was still upheld except in circumstances where the district court clearly and plainly said that its sentence would not be affected by the guidelines. And I listed in my brief the cases from this circuit: Mills, Gomez Jimenez, Doctor, Baronet, and Elbaz, and the reasons that those sentences were upheld despite the erroneous guidelines application was because the district courts clearly and expressly stated that their sentence would not have been impacted by the guidelines. By contrast, what we have, the state of the law, is, as Judge Heitens referenced from Melina Martinez at pages 330 to 31, are that the error itself can and most often will be sufficient to show a reasonable probability of a different outcome absent the error. Judge Niemeyer, you asked whether or not it would be possible that the court felt, because if the guidelines had been 360 to life, maybe the district court would have felt inclined to vary downward at that point. We don't even have to speculate as to whether the district court might have felt inclined to vary below the 360 months, because even if the guidelines had been, if they had been properly calculated at 360 months to life, we know the district court was contemplating even a within guideline sentence of 30 to 34 years. We see that at pages 1256 and 1257 of the record, where the court was thinking to itself that maybe a sentence that would get Mr. Kobe out of jail at age 63, 65, or 67 would be sufficient. If the range had been properly calculated, the district court would not have even had to consider doing a variance below 360. It still could have imposed the 30 to 34-year sentence, which would have been within the properly calculated range. But we clearly don't have that because, as was contended by the government at sentencing and as was on the brain of the district court, he knew that this was a guidelines case of life to life and that the government was asking for a guideline sentence of life. Your Honor, I would respectfully ask that you decide that this is the appropriate case to exercise plain error review. This is a plain error of constitutional dimension where there was a violation of the ex post facto clause. This is a plain error of the type that takes somebody from life where they could have gone down to 360 months as the starting point. Any one of us would have rather been looking at 30 years of potential incarceration as a starting point rather than life. And Mr. Kobe lost the benefit of that. And I think that it would really hinder the public's reputation of judicial proceedings to know that the district court missed the error, defense counsel, the prosecutor missed the error, the probation officer missed the error. Now this error has been recognized as clear by the government on appeal, but this error is just going to be swept under the rug, so to speak, because we think that recitation of the 3553A factors is sufficient. It's not. The Supreme Court has said so. This precedent in the Fourth Circuit has said that recitation of those factors alone is not enough, and there is no clear express language by the district court that its sentence would not have been impacted by the improper guidelines. Thank you so much.
Thank you, Ms. Coleman. I notice you are court appointed, and I want to acknowledge that expressly. It's a very important role you serve, and it makes our system especially unique in the world. It's thank you for your service and your good arguments. We'll come down and greet counsel, adjourn the court, sine die.
This honorable court stands adjourned, sine die. God save the United States and this honorable court.